What you have said mentioning?
My lordship's kind leave to mention, your lordship, a testamentary matter. Your lordship, is a contentious suit. Your lordship, the discovery, inspection, everything has been completed. Judge's proof of documents is also ready. Your lordship can include, your lordship, this matter for the framing of issues, your lordship, any day, your lordship's convenience.
Who is for the other side?
I've given notice, your lordship, to the other side, Taposh Kumar Sinha.
To be mentioned.
Grateful.
Lord, may I have your lordship's leave to mention a matter? It was your lordship's pleasure to fix the matter tomorrow at 12:15. My lord, the defendants have also given a mentioning notice. They are seeking an accommodation, and tomorrow my witness is also unwell because of the ensuing heat. So I was humbly praying, my lord, if it can be fixed any day, my lord, next week.
Why is your other side?
I have served, my lord. They are not appearing, but they have also given a
To
notice.
be mentioned tomorrow? To be mentioned tomorrow, what can we?
Yes, this is the last order that your lordship was pleased to pass.
Tomorrow is fixed for.
12:15, it was fixed for witness action.
So, what is the problem?
They have not completed, my lord, discovery inspection. We have completed everything.
Okay, come back tomorrow to be mentioned.
I don't need to mention a testamentary matter, my lord. My lord, an application has been filed for expunging the name of plaintiff number 2 because he has passed away. My lord, the matter was returnable on 25th as new chamber. My lord, I was only seeking if this matter could be listed under the heading new chamber for expunging the name of plaintiff.
Can't hear you.
My lord, I have filed an application for expunging the name of plaintiff number 2 because he's
Why?
passed away.
Why?
My lord, he has passed away, so his name has
passed
to be
away.
deleted. But the matter was returnable on 25th of April, but it was not in the list. So I'm praying for inclusion.
नहीं करो देखो देखने okay.
You have said commercial division. Item number 1.
And for the judgment debtor,
What about the decree holder? My lord,
there was a direction for re-inventory by the receiver. Now I find that the receiver, I believe, for today, let him give a copy of it.
maybe come back, my lord, next week, next Friday.
There was a direction that the inventory should be done at the suit premises, but I have taken instructions from my advocate record that the re-inventory was done in some warehouse, not in the suit premises. So I will, after seeing
Yes,
report,
my
I
lord,
will
that's
come back.
because the materials had been shifted over there.
And I am also being told that the receiver, the materials which originally
Your advocate on record was present when the inspection was done. Why he has not raised objection? That is has. But turned down.
No, this has not been turned down. But he has lodged formal objection. Your lordship, he said
Formal objection or informal objection. What is the difference?
decree holder said that these materials have been shifted to a warehouse.
Oh.
That's why it was not found. Now, the advocate record informed me that the receiver could not find any of the materials which he originally found when he visited the
Because the possession was handed over.
Yes.
So
he did not find the materials which he have taken inventory.
But let me consider the report and come back, my lord.
the learned counsel, the learned receiver or special officer, what?
Receiver. Remuneration.
Have you received everything about your remuneration? If you have any problem, you can ask me. Okay. The learned receiver has submitted a report on after completion of inventory. Stop. Let it be taken on record. Copy served.
Your lordship, I have served a copy in the court.
Stop. The learned counsel for the judgment debtor has sought for an accommodation.
No,
Both parties, but consent of the parties.
Both parties.
Your lordship doesn't put entire blame upon. He is also joint prayer.
Not blaming. The learned counsel for the parties have sought for accommodation. Stop. This is the matter after 10 days.
Your lordship, may kindly record that a copy has been served to the parties.
Copy served have been noted.
Grateful.
Grateful.
Copy served লেখা আছে তো? Copy served লেখা একটা লিখে দিন তো।
Copies of this.
Copy served upon the learned counsels of the parties. যেখানে receiver
Your lordship, will it be your lordship's pleasure to discharge me or?
No.
Very well, your lordship.
Whether you have carried out
Very well, your
inventory as per my direction, I have to see.
Entitled to further remuneration, learned friends should stay.
Yes.
We have no objection.
Grateful, your lordship. Item number 2.
My lord, I appear, my lord, for the decree holder. My lord, sorry, my lord, I had to appear virtually. My lord, it has been signed. The terms of settlement has been signed, my lord. Only signature left is Mr. Gaggar, my advocate on record signature. Otherwise, my lord, the judgment debtor has signed. Their advocate has also signed. In course of the day, my lord, Mr. Gaggar will be signing the terms of settlement, and it will be, my lord, stamp punched. My lord, we'll keep it tomorrow, my lord.
I'll keep it
We'll
tomorrow.
yes, yes,
Not today, not today.
I'm grateful.
yes, my lord. Grateful, grateful, my lord. Grateful.
Enough.
Original side matter to be mentioned item number 1.
Proposed copy of amendment. Why this amendment is required? Whether it has been granted?
Yes.
Probate has been granted.
No, no, no.
What happened? Tell me.
Allowed, my lord, post-title amendment.
Allowed.
Post-title amendment allowed.
So why now
You are right, my lord, one page, my lord, missed.
one page missing? Then how can it be possible for me, madam? এটা ওখানে কি বলছেন ওই অ্যামেন্ডমেন্ট অ্যালাউ হয়ে গেছে তারপর একটা পেজ মিসিং হয়ে গেছে এটা কি করে হবে?
With reading.
Have you made any prayer before me?
Yes.
What is the prayer? কোনো পিটিশন আছে?
Disposed, my lord. Here three.
She has been disposed of.
Yes.
Then how can it be possible for me to pass
My lord.
leave? Why? What leave? You have to
Marking.
what do you require? You have to tell me.
My lord. Writing, my lord. Annexure C, my lord.
Annexure C.
No
Yes.
intimation certificate. my lord.
No no intimation. It is left. You have forgotten. এটা কি?
Reading, my lord.
Leave is granted. লিখে নিন তো leave is granted
Annexure C.
to make the proposed amendment in Annexure C.
No intimation certificate.
That is no intimation certificate. Go out of the list.
Item number 2.
My lord, this is probate proceeding, my lord, on consent of the legal heir. So the last occasion, your lordship was pleased to direct to produce the death certificate of all the attesting witness of the will, as all the attesting witness has expired. I tried to prove this will by attending witness. My lord, those are so old, my lord, though we have got the reference of the corporations, date details, but need some time. Nowadays will take time. Kindly, lordship, kindly give us 4 weeks time to
Okay.
submit.
So after summer vacation,
After summer vacation, your
the
lordship.
learned counsel for the petitioner has sought for accommodation for producing the death certificate of the attesting witnesses.
Yes.
To the will.
Yes.
Stop. List the matter after summer vacation. একটা date দিয়ে দাও তো।
10 June. Lordship. Applicant.
Item number 3.
For the judgment debtor, lordship. Hearing for the decree holder, your lordship. On the last occasion, your lordship had directed that the undertaking required to be corrected. So I have already served my learned friend. May I file the corrected
Yes.
undertaking?
Now, where you have mentioned that you shall undertake, in which paragraph?
I shall just indicate your lordship. Kindly take paragraph 8, which is at page 4, your honor. I say that the decree holder shall abide by the outcome of the judgment letter's appeal preferred against the said judgment and decree dated such and such, being APD 17 of 2023, and shall not act in derogation of the law. And I have also indicated that the decree holder undertakes to restitute the judgment letter in the suit premises without any hindrance, in case the said appeal succeeds, and shall follow the directions passed therein and act in terms of the law.
আমার judgment anything you can.
My lord, what I want to submit, my lord, there are two appeals pending against my learned friend's client. My lord, one appeal is against the eviction decree, another appeal is against your lordship's last order. My lord, we have mentioned the appeal on 29th of April, before the division bench. Considering the urgency, my lord, the honorable division bench has kept the appeal, both of the appeals on Monday.
You have forgotten
top.
that EC application, EC number 330 of 2020 has been disposed of by this court. Okay. I am saying that, do you have anything to say about this undertaking or the affidavit filed by?
I'm being led by Mr. Madhur.
Just received a copy of this undertaking. But just two issues are there with regard to this undertaking, which your lordship is specifically asking. My lord, one is, my lord, it says the undertaking is on them, my lord, saying that they'll abide by the paragraph 8. They'll abide by the outcome of the judgment debtor's appeal preferred against the said judgment and decree dated 12th April 2023, being APD 17 of 2023. The twofold submission here, my lord. This undertaking should also be, my lord, in respect of the appeal which I have preferred, my lord, against the order passed by this executing court. Because if I succeed in that appeal, then even your lordship's order directing the receiver to hand over physical possession will also
And
go.
when I first this order,
This
this
appeal was not.
was not present. And another thing is that I have specifically mentioned, this is between myself
Yes.
and
Yes,
that.
yes, yes, of course. Of course.
That to the effect that in case the relevant appeal,
My lord.
that what has been inserted,
Yes.
succeed, he will restitute the judgment debtor in the suit premises without any hindrance.
That is
The
as per
main appeal is
para 28.
that appeal.
Yes.
That's right. That's right. No doubt
Okay.
about it, my lord.
Your appeal of this, you have filed another appeal
That's right.
against this court's order.
That's right. The 12th April
Okay.
2024
So,
order.
I do not think that.
Well, and the second submission, my lord, is this, my lord. My lord, not only, my lord, if I succeed in the appeal, my lord, but in the event, my lord, the appeal court grants me stay of the decree, then also, my lord, my humble submission is I should be restituted.
Okay, then you can please come back and we shall consider.
But-
And you please succeed. You
No, no,
please-
sir. My lord,
Because
I-
at
my-
this point of time, there is no state.
That's right. I agree.
Considering the urgency, the matter has been
I cannot,
kept in the first 5
check it.
applications.
Asun, Asun.
Only been
Well,
upgraded, that is all.
And the matters appearing before the division bench in the top 5 matters.
It
What
shall
time?
appear. It shall appear on the 6th. It is not
Yes.
appearing, it shall appear on the
Yes.
6th.
Have you brought
First 5 new
have you brought any stay order?
No, but I brought an order from the division bench, my
That
lord.
is pending.
That it is,
To
yes,
show
it
your
is.
lordship, my lord, that the division bench has appreciated that there is urgency in the matter
Yes.
and has directed it to be heard by keeping it in the top 5 matters, my
For
lord.
upgradation, your lordship.
That has
Urgency
that has
for
been
upgradation.
আসুন
allowed. The upgradation.
আসুন আপনি শুনবেন না আমি শুনবো আপনি শুধু আমার কথা শুনবেন হ্যাঁ The learned counsel for the decree holder has submitted one affidavit as per direction of this quarter of this court's order. Of this court's earlier orders. Stop. Copy served. Stop. Let the affidavit be taken on record. And on the basis of undertaking given by the decree holder, Ramnath Jhunjhunwala, Ramnath Jhunjhunwala, son of late Radha
Radha
Kishan Jhunjhunwala. দেখে নেবেন এই সামনেই আছে কি বললাম ওখানটা comma the learned receiver or special officer, what is that? Learned special officer oblique learned special officer is directed to hand over the physical possession of the suit premises to the decree holder on Monday তারিখ কত?
My lord, Monday is, my lord, 6th May.
6th May
6th May
2020 24
Kindly
at 4:30 p.m. unless he is prevented by an order of honorable division bench.
Yes.
Stop.
give-
Not before 4:30.
Only one request, my lord. Lordship will consider, my lord, reject it if required. Instead of 6th May, could your lordship keep it on 7th May? My lord? Just
Okay.
That 1 day liberty.
Okay, 7th May, that can be done. 4:30. Okay,
7th May.
7th May,
7th May,
4:30, your lordship. 7th May in the early hours then. They will have their chance on 6th.
Kindly keep it at 7th May.
7th May, 4:30. Okay. Everything is allowed in your favor. Only one thing is allowed in their favor. Okay, no problem. Okay, এটা রেখে দাও।
Lordship has kept the matter returnable.
9th May for report of
I'm
the
grateful.
9th May.
special officer.
Grateful.
আর কি আছে?
Cases, item number 4.
And may it please your
The
lordship.
judgment data model.
This is my application. Lordship,
Application for what?
application for remanding the judgment debtor to civil imprisonment. Lord, if your lordship sees the last order of 26th of February
The prayer,
2020.
prayer.
Yes, my lord.
This is a prayer.
That is the prayer.
Only prayer.
That is the prayer, because, my lord, it is my case that the judgment debtor, though has the means to satisfying the decretal debt, has evaded, my lord, the process of court and has not
Examination
satisfied
is
the.
over.
It's a decretal debt, my lord.
Examination is over.
Examination is not over because, my lord, on 26th of February 2024, the judgment debtor undertook to produce further documents, which he has failed to do.
None appears on behalf of the
That is
decree
the
holder.
last day.
Although
26th.
learned counsel for the judgment debtor is present.
Yes, my lord. That was one occasion.
Mr. Shatarup Banerjee.
That is one occasion. Lordship sees in last 3 years, my lord, I have been constantly there. There have been several accommodations granted to the judgment debtor.
To both sides it has
No,
been
no, no.
granted. It is
Not to
that
both sides.
Yes.
To us only.
Huh.
Both sides.
What happened? GA কি আছে দেখি?
Lordship sees the order of 26th February 24 once.
26th February.
Yes.
Yes.
The judgment debtor Pulak Ghosh is examined in part. He undertakes before this court that he will try to produce certain documents as per his statement made before this court within 15 to 20 days. We are in April. Nothing has been produced.
He has to
Or
come
then
to
he has to
work.
come. Then he has to come in.
He is there
Yes.
every day. He was there
No.
every day. He'll
So
come again.
examine.
He's not here
So today why will he be there? Today to the
because the
application
matter
was
is
put up.
returnable.
Whenever Lordship
So,
keeps it,
so have you submitted any documents or?
he has already submitted a few. My lord, he will be in the box. If you ask him questions, he'll produce it before.
I have asked questions. He was
Today
supposed
is
to
a very good
produce.
day. Bring him on 2:30.
Today, my lord, I don't think he'll be able to come. He is a patient, but tomorrow he can come.
Okay, tomorrow, fixed, tomorrow, date দিয়ে দাও. The learned counsel for the judgment data has submitted that the learned counsel for the decree holder may be allowed to examine the judgment data. Stop. The learned counsel for the decree holder agrees to such proposal. It agrees to such proposal. কেটে দাও, এটা কেটে দাও, এই লাইনটা কেটে দাও. Stop. Please the matter কালকে কত তারিখ?
Third bill.
হ্যাঁ. About 12:15.
Grateful, Mother.
12:15.
Lord, Lordship will kindly direct him to comply with the order of 15th.
If he has, he
26th
carry
February.
it. You ask him.
Because he was supposed to give.
The learned counsel for the decree holder has submitted that the judgment debtor should be asked to comply with the order dated. কত 26?
It's an undertaking given to court, my lord.
The extent that he has, mother.
Yes.
Yes.
Undertaking given when?
26th February
26
2024.
February 2024. Stop. The learned counsel for the judgment debtor has submitted that his client will produce the documents as per the availability of the
Yes.
said documents. Stop.
You can ask him question.
Come back tomorrow and fight.
Yes. And there is nothing to fight. He will only cross-examine. I have nothing to say.
Grateful, my lord.
Item number 5.
Lordship, I appear on behalf of the decree holder. Lordship will recall this is that execution application wherein the
For the Bangladesh.
yes, Your Lordship, the
Why is the other side?
Your Lordship, they were represented on the last occasion, and Your Lordship will recall and Your Lordship will find it in the last order that they had undertaken that they will take
Pass over,
very well, Your Lordship.
and try to bring your friend.
Lordship. Grateful, Your Lordship.
15 minutes. Okay.
Grateful.
Item number 6.
In this matter, my lord, I am for the decree holder, my lord. My lord, on 19th of March 2024, my lord, the decree holder company has gone into liquidation, my lord. And we have also preferred an appeal before the Honorable NCLAT, my lord. I am seeking, my lord, 8 weeks time, my lord.
The learned counsel for the decree holder
And also,
has submitted that the decree holder company
yes, ma'am.
has gone into liquidation, and as such, she needs some time. Stop. This is the matter after 8 weeks.
My lord, also the
Liberty to
extended,
pension
my lord.
হয়ে যাবে নাকি এটা? Go out of the list.
No,
Liberty-
my lord, 2 weeks after vacation.
That means 8 weeks.
My lord, also the interim order be extended, my lord. It
What
was passed
interim
on
order?
6th of March.
What is
my
the
lord.
interim order?
On 6th of March, it was,
No, what is the interim order?
my lord, the petitioners in the application shall not deal with or dispose of any of the immovable properties, my lord.
Have you served notice upon them?
My lord, they had appeared on the last date also.
So pass over. Let them come. Let them come. Pass over. Okay. এটা লিখে রাখো একটু, পরে আমি বলবো অর্ডার করি। অর্ডারটা এমনি থাকুক, কাটতে হবে না। 10-15 মিনিটে পাস ওভার দিন, ঠিক আছে?
Grateful, my lord.
Item number 7.
Item number 7, my lord, I am praying for leave to appear on virtual mode, my lord. I am of your lordship's officer, my lord, commissioner of partition, my lord, in this matter.
Yes, you are where now?
My lord, I am at Delhi right now, my lord,
Oh,
for medical reasons, my lord.
for your personal medical reason.
Yes, my lord, yes. I have my open heart bypass, my lord, a few days back. Yes.
What happened?
On the
Where is your other side?
The other side need not to appear because my lord, other side has given a letter to me that he has accepted the whatever accounts we have given, they have accepted point wise regarding the boundary wall, my lord, they initially objected. My lord, subsequently, my lord, good sense prevailed upon them. My lord, they have accepted that whatever accounts given by us were all reasonable and practical. That is why, my lord, they have accepted. They has given a letter to that effect also that they will pay us the amount.
Okay.
Only thing remains, my lord.
All issues are settled, my lord. Only my remuneration remained, my lord.
The only thing remains that the original deed and the documents, probate and other things which are like with the learned commissioner partition,
My
that
lord.
to be written physically. And my lord, the remuneration, what your lordship has already directed, initially 68,000, thereafter 1 lakh and 1 lakh, total 2,68,000.
My lord. For last 15 years, my lord. Yes.
My lord, the decree was passed in 2008. For 2018, thereafter, my lord, the pandemic, nothing happened. My lord, initially after my lord, the learned commissioner partition, he has filed the initial report, engineer's report and whatever that was done. And that cost of that thing was paid. And time to time, whatever this honorable court directed, we have paid. And thereafter, the matter, my lord, there are pandemic and other thing, my lord, and the appeal. By this way, my lord, now the matter has come to an end, and this execution is my lord, that was filed by us, and it has also come to an ending that defendants also not raising any other issue. Financial part initially they raised, but now right now they are saying that no, whatever accounts we have submitted, that is reasonable. Now the part of the learned commissioner remuneration that remains. And my lord, the last part of one physical meeting is required to be done by learned commissioner partition because he will be returning 2 weeks. And my lord, by that time we want to settle everything, my lord. So that
So after 2 weeks, I am fixing this matter.
after subject
My
to
lord, my lord, the remuneration, my lord, 1,86,000 is dues on account, my lord, commissioner of partition.
You please don't worry about it. Now you are on medical reasons. You are in the Delhi, so you please come back after your medical purpose is over. Then we shall consider your matter. Okay, matter regarding remuneration. They are raising objection on the ground of
No, my lord, in the meeting on last 30th, my lord, day before yesterday, in virtual meeting, my lord, parties have agreed upon, my lord.
Parties have agreed upon.
That 1,86,000 dues on the part of commissioner of partition, and so far as the clerk salary are concerned, 44,000, which I have agreed that I will forego that, but I will pay from my own to the clerk.
Okay. Okay, where is your other side? Where is your other side?
he has given a letter. He has
No. So far as the remuneration of learned commission is concerned,
They have
whether
they have raised an objection on last occasion also.
Yes, that's why I'm
the last meeting also they have raised objection. We personally, being an advocate, I personally requested Mr. Mukherjee that whether something can be done so that I need not to bother.
Yes,
the
something should be
honorable-
done, not in this fashion, in this
Yes,
manner.
my lord.
Okay.
Because, my lord,
So I'm fixing it after 2 weeks. When you will be coming back? When will you be coming?
My lord, after the vacation, my lord, because from the locker I have to, my lord, release those documents, my lord, in the bank, State Bank locker, my lord, High Court branch.
Before summer, I think it should be done before summer vacation. It should be done before it. Please try.
Before summer vacation, my lord, I do not know, my lord, my issues are here, my lord. Just after reopening, my lord, your lordships kindly.
22nd, after
And in
22nd,
the meantime,
He may not be available. He's
let the
in
matter be
the meantime, my
not
lord,
available,
directed
then we
them.
shall try our
we are fixing. If you do not come, then we shall.
My lord, in the meantime, my lord, directed them to pay the remuneration in equal shares, my lord, by them, my lord. Your lordship directed them, my lord, yes, in the meantime, my lord.
How much you can pay?
1,86,000, my lord, yes.
No, 1 lakh is your
My lord,
claim.
yes, my lord, 44,000 of the clerk's salary, my lord, yes, which is determined, my lord.
Yes, he has
let us be very frank to that. My lord, something.
I do not want
all
to
these things. But
enter into the arena of advocates.
It is embarrassing to me also, your lordship.
Yes, especially reserved and all are actually going on.
What I am on, my lord.
I'll leave it to your lordship, my lord. Your lordship kindly settle in one shot, my lord.
Accounts.
It is embarrassing to me also. Yes.
monthly remuneration of learned commissioner of partition, which is not done, which was never
Now,
done.
how much you want to pay now?
Well, 2,68,000 for a partition suit for 1 foot share, well, whatever it is, we have paid 2,68,000.
No, jointly, you two,
Jointly, I think, my lord, as an advocate and
Yes.
as an officer of this court, we should not pay not more than 50,000
both.
altogether.
All
2,60,000, 2,60,000 or 2,70,000. Another 50 means 3,28,000, 20,000. So 3,20,000 for a commission work. My lord, I think this is not unreasonable.
Okay, I do not want to make any comment. Please consider. Please consider.
I think this
Hey,
would be, yes,
the
sir.
learned counsel for the parties, no, the learned counsel for the decree holder is present. None appears on behalf of the judgment debtors. Stop. The learned partition commissioner is present on virtual mode. Stop. According to the learned counsel of the decree holder, the matter is going to be settled very soon, but only the aspect of only point of remuneration of learned commissioner is pending. Stop. The learned counsel for the decree holder has suggested that they will
By all the parties, my lord, all the parties.
they will settle the issue of remuneration with all concerned parties along with the learned commissioner. Stop. The parties are directed to pay the balance amount of remuneration to the learned commissioner
My lord,
in consultation. Yeah.
pay the balance amount means the 86.
No. Agreed upon by the parties, including the learned commissioner. Okay.
I don't understand.
My lord, they will never
All
agree.
parties have to agree upon the including the commissioner. That is my motto. Okay, you please come back and we shall decide. Okay.
My lord, living apart, my apart, my lord, they are, my lord.
This matter should be done not before me. This is my
Yes,
request to
yes,
all of you. Okay.
Yes, they should consider, my lord. I'm living apart, my lord. I need, my lord, 50 meetings up to date from the inception, my lord. In each meeting, my lord, 3-4 pages handwriting, my lord.
Yes,
by
you see.
Not even call for a stenographer, my lord. Stenographer will take more than lakhs of rupees.
Matter is going to be settled.
And my learned senior friend, my go on record,
Who is your senior?
40 years of more than 40 years of practice.
Yes.
Yes.
Is in our high court's precedence.
Yes.
No commissioner, no special officer, never
Okay,
open
this
their
should
mouth.
not be discussed
They
here.
always appear with a counsel.
Okay.
My lord, this is something, my lord, kindly.
Okay, you please decide this outside court.
Let me, my lord, let me record, my lord, kindly
My lord,
record.
Mr. Dotto, in beforehand, Mr. Hero Mitro learned senior counsel, Mr. Malagos represented the plaintiff decree holder.
Yes.
But by a letter dated 1st of May, but the defendants have given that they have no objection regarding the other part of the accounts.
The letter of the letter
1st of May,
given by the learned counsel of the judgment debtor to the learned advocate of the decree holder be taken on record.
The parties have given.
The learned counsel, no, not
Defendants.
the judgment debtors. The letter given by the judgment debtors. Okay? To the learned counsel of the decree holder.
It is addressed to me as well as Mr. Learned Commissioner, the plaintiff.
The letter given by the judgment debtor to the learned counsel of the decree holder be taken on record. Have you submitted?
1st of May, I am getting it printed within 5-10 minutes.
Letter dated 1st May 2024. It'll लिखा है. Okay, come back on when? If he is not available, then again.
My lord. And my lord, by humble prayer, my lord. My humble prayer, my lord, I have been appointed by the honorable court. My lord, whatever I leave it to your lordship, I leave it to your lordship, my lord.
You are
My
my
lord,
officer.
it is embarrassing to me also, yes, my lord. They should consider, my lord.
Don't
Property,
become,
there are two suit premises, my lord, just opposite to Calcutta Medical College.
you are on your medical leave. Okay.
My lord, my lord,
Don't become
my lord,
agitated. Right.
my lord, please.
Okay.
My lord, I am grateful.
8 কত
15th, after 15 days, my lord.
কত হচ্ছে তাহলে fortnight?
No, 15 days.
22 22nd. Last date 24, not 22.
22nd.
22nd.
My lord, kindly, I will try.
Okay.
I'm with you.
একটু বুঝিয়ে লিখে দেবো হ্যাঁ
Item number 8.
My lord, I am grateful.
Yes, what happened?
Lordship, today we have been given a copy of an Aadhaar of the new official trustee. Lordship, perhaps an order would be required because the earlier document was presented to the registering authority with the earlier person's name. He will not change unless your Lordship's order records it. The Lordship will take your Lordship's order dated 20th February 2024.
20th February 2024.
The Lordship will find your Lordship had directed the erstwhile and the deed was approved.
This should be sent to whom?
Lordship, we will send it to the registering authority, but only an order is required that recording the
The
name
learned
of
counsel
person.
for the judgment letter number 1 has submitted that the new incumbent as official trustee of West Bengal has joined the office, and he has further submitted one Xerox copy of Mr. Chinmoy Chattopadhyay, duly signed by him. Stop. The decree holder is given liberty to send the certified copy,
Lordship, the Xerox copy is adequate to be given.
Xerox copy of the
Lordship, we need to change
State-
the name and the deed.
state Aadhaar card to the concerned authority in accordance with law.
Lordship, concerned registering authority.
Concerned authority is sufficient. It will help, it will include all authorities. Okay. Not only one authority.
Lordship, one more indulgence, the PAN card perhaps is also required.
You can find. PAN card, personal PAN card, I cannot give direction. Okay.
Lordship, that's a requirement of the
Nah, I
registrar.
cannot give this issue, I cannot enter into. Convince your officer, okay? He's a seasoned officer, he knows everything, okay? He's a very good officer, don't worry.
Lordship, may I take back this to be handed over to the registering authority?
Yes. Has submitted that I will submitted.
Lordship, to the Xerox copy, shall we hand over a Xerox?
Yes, the Xerox copy. Okay, well, Xerox copy. A Xerox copy of Chinmoy Aadhaar card. Okay. Returnable after 2 weeks.
Customer matter, item number 5.
Not today করে দাও কি করা যাবে
Item number 6.
I am for the decree holder, my lord.
The company has gone into liquidation.
Yes, my lord. We have also preferred an appeal, yes. We had preferred an appeal, my lord. The matter is still pending before the Honorable NCLAT, my lord.
So
I have-
he needs some time.
Yes, my lord.
After summer
After
vacation.
vacation, yes,
Okay.
my lord.
এই এটা লিখে দিন, ওটা কেটে দিন আগেরটা। আগেরটা কেটে দিয়ে লিখুন, the learned counsel for the decree holder has sought for accommodation. Stop. The learned counsel for the judgment debtor is also present. Stop. List the matter after summer vacation.
The interim order, my lord.
Interim order is extended till the till 15th June 2024 or until further order. Okay,
Or interim order be extended, my lord.
okay. You come back on 15th and we shall consider. Okay. So you have to take up the hearing then if they have no locus standi. Are you ready? Yes, tell me.
Well, I am praying for 8 weeks time, my lord.
So why 8 weeks time?
Because, my lord, the company has gone into liquidation, my lord. That is why I am seeking.
Then why I shall extend your interim order without hearing the other side?
It was
You
passed
hear?
6th of March, my lord.
I have to take up the matter in presence of the other side.
Well,
I want to
pursuant
hear.
that
I
order,
want to
my lord-
hear.
My lord, pursuant to that order, my lord, they have also preferred an appeal.
Okay.
Well, no stay has been brought by them, my lord. The matter is it is appearing, my lord, but
Okay,
it is not.
Then take
hearing for
15th
hearing.
June.
Yes, my lord.
15th June.
I'm grateful.
13th June. 13th June. Okay.
I'm grateful.
Chamber application. Item number 12.
My lord, I am for the plaintiff propounder of my lord, will. My lord, the will, my lord, was dated 8th September 2009. My lord, testatrix, my lord, passed away on 5th September.
Which
5th
for the
July.
other side?
My lord,
Oh,
5th
you have-
July 2011. My lord, this is my lord only for my lord examination, my lord, my lord, of the two attesting witnesses of a will. For my lord, quite my lord.
No, what happened? I am a newcomer.
My lord, may I just my lord try and explain?
Yes,
my lord?
please.
My lord, probate application was filed, my lord, on 2013.
2013.
2013.
Yes.
In respect of my lord, testatrix, my lord, whose will is dated, my lord, 8th September 2009.
Hmm.
My lord, there are two attesting witnesses
Hmm.
who are, my lord, little advanced in age and not very well. So, my lord, we have made this application for the purpose of, my lord, their examination, either, my lord, in court, essay, or, my lord, required, my lord, by commission, my lord, for their examination.
Hmm.
So that, my lord, by way of advocate commission, I don't know why my learned friend, my lord, would oppose such an application. It is really, my lord, to expedite, my lord, the hearing of the suit.
Okay. Why? What is your contention? What are those applications?
That is irrespective. How does that?
What is your capacity? You have lost. So you prayed for amendment of affidavit of assets filed by them.
Yeah. He wants, my lord, there's something, my lord, which is there. I've never heard this application. My lord, in the
There
affidavit.
is a provision.
My lord, in the
Order 6, Rule 17, but we do not go through the Order 6, Rule 16. That is different issue.
Affidavit of asset, my lord, which, my lord, the will describes the property.
Yes.
Now he comes and says that no, you delete that property from the will, from the affidavit of asset. I can't do that. As a, my lord, as a that is, my lord, that let that happen. But this is, my lord, examination.
Without that application being heard, my lord, this application is being made. So I'm praying for directions for opposition.
Well, you did not file a affidavit in opposition.
First time it is appearing.
Yeah, they have right to file affidavit in
My
opposition.
lord, I leave it, my lord, entirely, my lord, up to my lord. I would have, my lord, insisted on the application because I don't know how, my lord, they can oppose, because particularly, my lord, when they're in other forum, my lord, they're going and saying that we are delaying, my lord, the trial of
I
this.
have given you them within
Kindly give, my lord, very short affidavits, my lord.
Yes.
We can come back, my lord, before the vacations as well, my lord.
So I'm praying for 3 weeks. Decide of the vacation.
Kindly see.
Then I shall allow.
2013 probate application,
I
they are
have,
opposing.
I have understood that you have certain problem for not filing affidavit in opposition. But if you think that I can give you 1 month's time, I cannot. No, it is not possible. 2 weeks sufficient. 2 weeks.
2 weeks, my lord. Kindly give us 3 days, my lord, to file a reply, my lord. We'll come back before the vacations.
So you know everything. You have opened your mouth. You know. You know everything, so you are ready with the factual aspects of the matter. Hey, asun. The learned counsel for the defendant, one or many? How many? One defendant has submitted that he wants to file affidavit in opposition against GS 7 2024. Stop. Let the affidavit in opposition be filed within a fortnight. Stop. Affidavit in reply, if any, within 3 days thereafter. List the matter on 22nd. হয়ে যাবে তো? দেখো তো ঠিকঠাক হলো কিনা? 14 দিন, 22nd or 21st?
22nd, my lord, is 15 days. 22nd.
24th হবে?
24th.
24th. Okay. ঠিক আছে, থাক না।
24th. If it can be done, my lord, it will be done, my lord.
Otherwise,
yes, otherwise, my lord, anyway.
Luck may favor.
Luck may favor them on me, my lord, to have that application heard out.
Okay. Try.
My lord, kindly see, no urgency. Other forum, my lord, they're saying we are, my lord, not getting, my lord, the will done.
He is submitting on instruction.
I know.
Your brother.
My lord, in fact, my lord, it should be recorded, no urgency. Because, my lord, we can go and show other forum, my lord, they say no urgency. Correct.
It's okay. So
Grateful,
then, 24th. Okay.
24th.
Okay.
I'm
last
so
day.
great.
Okay.
Item number 30.
My lord, this is, my lord, the husband's will. My lord, similar directions can be given.
Affidavit in opposition, no? You have to
Yes.
file. The নাম্বারটা দেখে নেবেন, GS 7 ছিল তো, এটা কত হবে দেখে নেবেন।
GS 6, my lord.
Item
I'm
number
so grateful.
40.
Letter of administration has been granted in favor of the applicant before your lordship. It has already been granted without any will. So, my lord, I am to administer the estate. I am the sole legal heir of the deceased. My mother had also passed away. The issue now is, my lord, there is a property at Salt Lake which has been allotted in favor of my father. But the deed of lease, despite the entire payment being made, is not being, my lord, executed in our favor. So here where the issue is lying stuck. But the authorities are wanting a succession certificate, but I already have the letters of administration. So that is why, this application has been taken out in that PLA, where the letter of administration has already been granted in my favor,
including this property.
Including this property.
Show me that.
But the problem is, this property was at the allotment stage. I am not yet declared an owner. It has been allotted in my favor. Your lordship knows, Salt Lake properties. A lease has to be, my lord, allotted in favor of my father. So, my lord, a lease deed has to be executed. The issue is, my lord, it is stuck at the allotment stage after payment of the entire consideration.
Allotment
of that particular plot of land.
by government.
By government. The process is, my lord, they allot the land. They ask us to make payments. Once all the payments are made, my lord, then they will execute the deed of lease in my. Now, in the interregnum, my father passed away. My mother is also no more. So I am the only legal heir. That lease has to be executed in my favor. I have applied for, my lord, the letter of administration. They asked for.
Lease was not executed.
Lease was not executed. Allotment was.
But there is the allotment notice.
Allotment notice, payments made.
Whether it has been noted or mentioned there that in case of the allottee dies before, the legal heirs will be entitled to.
না order না জজ সাহেবের প্রশ্নটা অন্য।
Administration will do.
Now, the allotment letter, my lord, will find at page 9.
Page 9. Yes. This is in the year 1982.
Yes.
Then
thereafter, my lord, payments have been made.
When payments have been made?
But kindly comes to, my lord, page 31.
So
the last payment made
this was
in
not
2000.
executed. This was not executed. Now the government policy is not giving 999 years. They are giving only 99 years. Oh,
whatever it is, whatever the policy. I'm not asking you any order to amend any policy.
No, but
only a direction.
1982 allotment.
Allotment 1982.
But
And payments made in 2003.
no.
And your lordship will see the letter of the government authorities.
Yes, after 2003,
Yes, your lordship will see the communication with my client.
Yes.
That is the petitioner before your lordship. They are wanting a succession certificate, but we already have the letter of administration. So it is on this issue that this is lying stuck.
The government is not a party to this proceeding.
No, but
you can file an appropriate writ application then. Why you have come
your
over
lordship
here?
kindly comes to page 44 once, possibly, your lordship has the jurisdiction, possibly, subject to your lordship's kind consideration. Your lordship will kindly have a look at page 44.
Yes.
The petitioner claimed to be the only legal heir of the allottee, late Shivananda Chatterjee, appeared in file Hajira. On 28/5/1982, a plot of 5 quarter of land at Sector 5 was allotted to the allottee. However, due to negligence on the part of the allottee, till now neither possession of the land was made nor any lease deed was executed. Now, Srimati Mojumdar, with a letter number such and such, wanted this department to execute the lease deed in our favor. Now, in order to prove the legal heirship of the deceased allottee, Srimati Mojumdar is required to submit succession certificate from competent civil courts. She is also required to submit her detailed plan of action in the said plot, detail of DPR, financial solvency, building construction, etc. Is now directed to submit documents within 2 months. Now, I have been granted the letter of administration.
Letter of administration is in respect of immovable properties, movable properties, but it is not your property or your father's
What they are
property.
wanting is to get a succession certificate.
And I can give a succession certificate in respect of movable properties and immovable properties. How can I give a right, or if there is right, or you understand my problem?
I understand, but the succession certificate is just to show that who is the legal heir. So that is already fortified by this honorable court by issuing the letter of administration in my favor. So this is a surplusage which they are wanting. That is why I have come before your lordship, before the court which issued the letter of administration in my favor, that this should suffice. Only to that effect.
Oh.
Otherwise, nothing else.
No property is required to be mentioned here.
No.
What
Because
is
your
your
lordship
prayer?
will see,
What is your prayer?
my prayer is that this, upon to hand over peaceful vacant possession of the plot upon and direction to execute the necessary lease deed. The reason why they are not issuing.
No, how can I direct a government officer who is not a party to this proceeding? I can grant succession certificate that this property or that property.
Yes, my lord, may I humbly suggest one thing subject to lordship's kind consideration. My lord, if your lordship at the first instance passes an order recording that the date and the order by which the letter of administration has already been granted, and direction upon the authorities to consider that while issuing. That can be done, my lord. And your lordship will keep it pending.
দেখো তো এটা আর কি আছে কাগজপত্র নিয়ে আমার একটু চেম্বারে পাঠাও তো আমি দেখে
We have annexed the letter of administration, everything which has been granted. It's lying stuck.
Please
and the difficulties
flag it, please.
I shall. And one of the difficulties, two sureties are also there who are unable to be discharged. I have to file the inventory and accounts also. So I'm stuck.
ঠিক আছে.
Your lordship
Your
will kindly,
junior
my lord.
maybe asked to
Yes. I'm so
flag.
grateful. I'm so grateful.
Okay, thank you.
And also one thing, my lord, we also had.
But there would be no direction upon it.
No, just to record that this has been already granted, and
that
to
maybe
consider
that
that
maybe
by-
if I find
I understand what is falling from it. But in one other case, my lord, of this honorable court, a coordinate bench of my lord, where my lord, the issue was with regard to share certificates not being issued after my lord, the death. But there also, after the probate was granted, we had moved an application where this honorable court directed the company, who is not a party naturally to the probate, to issue the share certificates. But we have all these orders chronologically. If my lord so desires, my lord, we can hand up copies for your lordship's kind consideration.
Okay.
If your lordship kindly permits. We have included all the order sheets right from day one, where they were directed to serve, they appeared, and direction was passed on them to issue share certificates. This is somewhat similar, my lord.
Okay. এগুলো আমাকে দিয়ে পাঠিয়ে দিও আর ওগুলো letters of administration and all other things maybe.
Letter of administration and also there, my lord, that order where they correspondence.
Okay.
Your lordship will kindly consider. I'm so grateful.
না এটা আমি দেখে চেম্বারে পাঠাতে বললাম সমস্ত কিছু নেই ওই ট্যাগ ট্যাগ করিয়ে নাও ওকে না আমি দেখিনি, আজকেই অর্ডার দিয়ে চেম্বারে গিয়ে অর্ডারটা দেবো।
Item number 15, 15 and 16.
I have the executor in item number 15. This is that application, your lordship will
15.
remember. Yes, my lord. My lord, your lordship will remember. This is where, my lord, inventory of a locker facility of the deceased was, my lord, in question. We had initially taken out an application, my lord, which is GA number 1 in connection with the PLA application. This honorable court was pleased to pass an order for the locker to be opened and inventory to be made in the presence of the bank officials and my client. When I communicated the order to the bank informed me that, sorry, we cannot do this because that account locker has already been given away to a third party. I report back to the court. The court asked for affidavits to be filed by the bank as to how this locker belonging to the deceased could be assigned to another person without any inventory being made. If any inventory was done, to disclose the particulars of this inventory. A series of orders were passed. Your lordship will find from the orders itself. Time and again, the bank was playing hot and cold. They initially did not file an affidavit. Finally, an affidavit came.
You are for the executor.
I am the executor.
What is your name?
My lord, Shomorjit Raha.
And who is for the beneficiaries?
My lord, Shomorjit Raha is also the beneficiary.
One of the beneficiaries.
My lord, the original beneficiary was the sister of the deceased, Shondha Kaur. She has died. So the will provides in the event of death of Shondha Kaur, it will go to the executor, who is Shomorjit Raha. So he is
only one.
Only one. And he is a nephew.
Yes.
Now, my lord,
Based on a will was executed on a subsequent the latter will.
Okay, I shall hear you.
Yes. No copy of that application has been served on us. Now, my lord, your lordship will just, my lord, the facts are like this. My lord, the deceased is Juthika Kaur. She was unmarried, issueless. There were 3 brothers and 4
all
sisters.
parties here.
Yes, my lord, the relevant parties are there.
And all parties are ready.
Yes.
No problem. There will be no prayer for accommodation. Okay.
But it will
So
be
I
a
have
little
to-
premature for me to say that all parties here are here because, my lord, so far, my lord, there is only one person who was liable to be cited, who was a class 2 heir, because there are no class 1 heirs alive.
Yes.
Mother, father, both dead, unmarried, issueless. So one brother, my lord, Komal Krishna Kaur, was the only person, my lord, who was a class 2 heir, who had caveatable interest, my lord, and is entitled to caveat, to citation. But, my lord, even before that stage arrived, my lord, this is at the absolutely nascent stage when I filed an application for locker inventory.
Just a minute.
Yes,
You must start. You are executor and beneficiary.
I am the executor and beneficiary. Shomorjit Raha, who is a nephew, being the son of a sister's son.
Son of Juthika Kaur.
Well, not son of, nephew. Son of Maya Rani Raha.
Sister's son.
Sister's son.
Nephew, son of Juthika. Sorry, sister, son of Juthika.
Yes. And, my lord, the parties before your lordship, other than me, is, my lord, one is Bank of India, Beleghata branch, who is the bank, my lord, who was, my lord, with whom, my lord, the locker facility was there. And, my lord, Mr. Banerjee's client, who is Mrs. Mithu Kaur. Mithu Kaur, my lord, in relation, is the niece-in-law or brother's daughter-in-law.
Juthika's brother,
who is Bimal Kaur, his daughter-in-law is Mithu Kaur.
Yes.
Who has also filed an exception to the bank's report.
Yes. And Mr. Banerjee is representing her.
Is representing Mithu Kaur.
Yes.
Now Mithu Kaur is the person who is presently the locker holder. The locker which originally belonged to the executor as a joint, to the deceased, has now been jointly with a brother and a sister. There were 3 joint holders.
Yes. What is
Bimal Kaur,
what are, please, Bimal Kaur?
Tika Kaur and Sundha Kaur.
Sundha.
Today, my lord, all three are dead. Bimal died in the year 2010.
Just a minute.
Yes, my lord.
Jutika,
Bimal and Sundha.
Sundha, and brother
Bimal.
all three died.
Yes. Now, my lord, Bimal died in 2010. Jutika, my lord, who is the deceased, died in 2018. And Sundha died in 2019.
19.
Yes.
Yes.
Now, my lord, I'll show your lordship from the papers, my lord, which have been filed by the bank with their report.
Now, what is the problem?
The problem is this. My lord, this
One locker.
the account, the
One locker
with Bank of India.
with Bank of India, Delegate branch.
Yes. My lord, the articles lying in the locker are part of the estate of the deceased.
Yes.
The deceased had made a bequest in terms of the will, by which he had also included the articles lying in the locker account to devolve upon the beneficiary. Now, as we usually do, the moment we file the PLA, we file a GA application if there is a locker involved. So that directions are given, locker is opened, inventory is made, and then I can include those in the assets, the affidavit of assets, because my affidavit is still incomplete without all the articles being reflected. I take out the GA application. Order is passed directing
GA 1.
When I go to make inventory, the bank says, I'm sorry, I cannot allow this inventory. There is already this account, this locker has already been allotted to another person. So I'll have to inform that other person before I can do anything. I say, very well, you inform that other person, another date is fixed, we all go there.
So you have missed one point, whether that locker is jointly or
Jointly.
Jointly with whom?
With these three persons that I mentioned, Milad.
Oh, Jutika, Sunda, and
Bimal.
Oh.
Now, Milad,
Just
when
that one locker with So this is a locker of Jutika, but jointly held.
Jointly with
Or
Bimal
it is the locker of Sunda jointly held by. What is that?
Well, all three of them are named as joint holders. I'll show your lordship the account locker opening form. It has been disclosed by the bank.
Jointly by three
by these three. And
Just
there are clauses.
See the affinity between all these three and what you are doing now.
Affinity was there, no doubt. But they had also fallen out later on. Because there was a lot of litigations, partition suit, of the family assets.
Okay. Okay.
Lot of
Jointly by three
litigation.
brothers and sisters. Okay.
Now, the application GA number 1, order was passed on 22nd December 2022 for opening.
GA 1 at your instance.
At my instance.
GA 1 2022.
Yes, 22nd December 2022 order is passed for inventory of locker to be
22nd December 2022. In presence of?
In presence of bank officials and the executor.
And who was the special officer?
No one was appointed. Bank officer is to carry out the inventory in the presence of the executor. That was the order.
Learned counsel of the executor.
Bank officials were to carry out the inventory in the presence of the executor.
No learned advocate.
No.
Even executor's learned advocate is not allowed. Okay, I have to go.
Now, once this, so when I went to the bank says that it has been allotted to another person. Another date is fixed. That person comes. It turns out to be Mr. Anergy's client. In the presence of everybody. Yes, the locker is opened. And no articles are found. It is an empty locker. Now, when we come back to court and report the matter, the court says that how could this locker be allotted to another person without ascertaining who the legal heirs of the deceased was, because she is one of the joint holders, admittedly.
Show me that order.
Yes, kindly has a look at the 7th August 2023 order.
Order 7th.
May I request your lordship
2023.
If your lordship takes up the bank's report, all the orders are serially annexed. It will be best, they are all there.
Bank's report.
That is 10th October 2023. This is an affidavit.
Report dated 10th October 2023. This is the exception. It no.
10th October 23.
While your lordship officer is looking for it. But Mr. Mukherjee will just indicate what he wants now in this application. He'll cut short because his prayers have all been granted in
No.
PA1. What else does he want? If you could indicate, if he wants
He,
the locker,
he wants jewelry.
that was found, it was empty. He wants jewelry, I can understand.
I'll clear.
Water box is not there today.
It has actually been
If
removed.
it's been removed,
A
whatever
locker
he has
lying empty for the last 5 years. How many it could be given to a person? It belongs to the estate.
If you could just
He
indicate
wants
what he wants.
to cut short the matter. How can
That's
it
right. You
be?
can just finish it.
Well,
That
today,
can be done in the
today,
court proceeding.
a report was called for.
If he wants the locker, I can give up my right to the locker. He can't have anything. It was empty. It was empty. Now
Today, as the executor, my lord, I am concerned with the estate.
Hey, this is the exception
The
to the
assets.
report. Exception. Exception to the report submitted by Bank of India.
No, it
No,
is
no.
their report. It can't be an
What is that?
exception to their own report.
Then report is not 1010. Yes, please.
let him just indicate what he
Well,
wants.
I will.
Save your lordship for not.
Well, may I just show your lordship the orders first? Your lordship,
I have cut short the matter, but you did not agree.
I'm agreeable to having it cut short. He wants the locker, I can give up my right to the locker. So the locker is empty
There's no
today.
question of my taking the locker. Well, the assets
please.
are what is the
Please,
concern
please,
of
please.
Yes, well,
Yes.
kindly comes to page 4.
7th August.
Yes, well, 7th August. And this is, well, I'm just placing it shortish order. On 22nd December, so and so, an order was passed in this application directing locker bearing numbers such and such, maintained with Bank of India, Velegata branch, to be opened on the basis of the submission made by the propounder. It was submitted that the locker was jointly maintained in the name of Jutika Kaur, Bimal Kaur, and Shondha Kaur. It was submitted that Bimal Kaur predeceased Jutika, while Shondha died subsequently. The locker could not be opened on February 7, 2023, as no steps were taken by the propounder on the ground of illness of propounder's mother, and as such, a further order was passed on 7th February 2023. Time to open the bank locker was again extended by order dated 3rd April. Now, today when the matter is taken up, Mr. Such and Such, instructed by so-and-so, appears and submits that they have instructions to represent one Mrs. Mithu Kaur, who is related to Jutika Kaur and daughter-in-law of Bimal Kaur. It is submitted on behalf of Mithu Kaur that the bank locker is presently in her name and she is paying the locker rent. Now marks the next line. It is difficult to appreciate how the bank locker could be allotted to Mithu Kaur or Mrs. Mithu Kaur could be made a locker holder when the other locker holders are all dead. Bank of India, Belegata branch is directed to file an affidavit within such and such, stating the background in which Mithu Kaur became the locker holder or one of the locker holders and from which date. Let a copy be served on such and such. By way of abundant caution, order can be communicated. Now, Millet kindly turns over the page.
Yes.
Well, 28th August, they did not file this affidavit because the person apparently concerned with this matter was on leave. Then, well, the next order. Well, 19th September 2023. Bank of India, Belegata branch has placed an affidavit affirmed on such and such. The affidavit does not answer all the queries. Moreover, at the time when the legal heirs and heiresses of Bimal Kaur were permitted to become locker holders, whether there was any inventory made in respect of the locker is also not spelled out in the affidavit. The court, while exercising testamentary jurisdiction, is only concerned with the estate of the deceased, the genuineness, testamentary capacity, as also the validity of the will, and not with other issues. In the instant case, Bimal Kaur, Jutika Kaur, and Shondha Kaur, being brothers and sisters, had a locker in their joint name with Bank of India. Bimal Kaur predeceased the testatrix, while testatrix Jutika Kaur, Shondha Kaur, died after Jutika's death. Now, according to the bank, as stated in the affidavit,
bank was approached by Sanjoy Kaur, the son of Bimal Kaur, on or about 20th November 2021. Jutika died on 14th April 2018, while Shonda died on 9th March 2019. So, Sanjoy approached the bank much after the death of the original locker holders. It is important to know whether any inventory was made when Sanjoy was permitted to operate the locker after the death of all three original locker holders. This is more so necessary as the belongings of the testatrix may have been kept in the locker, which forms part of the estate and has been disposed of by the will said to have been left behind by Jutika Kaur.
Yes.
Now, two things come. One is Sanjoy Kaur, who is the son of Bimal Kaur, one of the joint holders, has independently approached the bank and applied for that locker to be allotted to him or his wife. First question is how this could be permitted when there were two other joint holders who survived Bimal Kaur, who is the predecessor of Sanjoy. Number two, whether the bank took any steps to ascertain who the legal heirs of Jutika and Shonda were. Because I'll come to the letter that Sanjoy has written to the bank. And the only assertion there is that I am the legal heir of Bimal. And number three, and most importantly, whether or not it was the duty of the bank to at least make an inventory to find out what are the articles lying there. Because I'll show your lordship also, curiously enough, they said that the locker key was lost. So the locker had to be broken open. And I'll also show the RBI guidelines in this regard. When a locker is broken open, there are additional measures that are in place. But the RBI has put in place in order to ensure some amount of safety checks. It has to be video recorded, the entire process. So even simpliciter inventory, even assuming that was done, would not have sufficed. And that also has not been done. So with impunity, I would hesitate to use any collusion, but it appears that the bank has acted at the instance of one of the parties.
In violation of RBI guidelines.
In violation of RBI guidelines, and B, completely prejudice the estate.
Allow them to speak. What? They have to speak.
They will have their chance, of course.
So
Now,
what is your prayer right now?
Today, there is no application before your lordship.
Then?
This report was called for by the court.
Oh.
When I came to court and I apprised the court that this is what has happened, the court itself asked the Bank of India to come.
Oh.
Bank was not there, not a party.
So they have to answer.
Bank was asked to come and file an affidavit indicating how Sanjoy or Me Too could have been allotted the bank account locker, and B, whether an inventory was made, because the articles is the concern of the court.
Okay, allow them
in testamentary jurisdiction.
Allow them to answer. Please, 2 minutes. Okay.
Now, again, the next order, 5th October, kindly has a look at.
Yes.
In fact, I will not trouble you. Again, they had filed an affidavit, but not given full particulars, inventory and everything, was not spelled out. Now, kindly has a look at the final affidavit that is filed before court. Paragraphs 4 and 5.
Lowly
at page 2.
Para 2.
Paragraph 4 at page 2.
Yes.
This is the bank. Bimal Kaur passed away on 16th March 2010. After the death of Bimal on or about 20th November 2021, kindly notes, 11 years have elapsed. Upon being approached by one Sanjoy Kaur, who claimed to be the sole legal heir of Bimal Kaur. And upon production of death certificate and KYC forms of Bimal Kaur and himself, Bank of India granted access of the said locker to the said Sanjoy Kaur. Your lordship will kindly recall, categorical direction observations were made in the order that it is an account held by 3 persons. They say that it was Sanjoy who approached. He furnished documents of KYC and whatnot, saying that he is the sole legal heir of Bimal. And bank happily granted access to the locker, to the legal heir of one person. Yes. In this regard, copies of the death certificate, affidavit, requisition,
yes,
and KYC forms produced by the said Sanjoy Kaur are annexed here to and marked with the letters. Now, 5.
Paragraph
No, yes, my lord, para 5. No inventory was done at any relevant point of time, including when the aforesaid Sanjay Kaur was granted access to the said locker. I say that no other person approached the bank requesting for access of the locker. I say locker was to be operated by any one of the erstwhile joint owners or the survivor. Since none of the holders survived and a request was made by the legal heirs of one of the joint holders after death of all joint holders as well as his mother to grant him, Mr. Sanjay Kaur and his wife, Mrs. Meetu Kaur, access to the locker, access was given to him. The mother says so and the bank says that I will grant access.
No, that, okay, I have to hear, I do not make any.
Access was given to Meetu Kaur pursuant to request made by Sanjay upon production of KYC of Meetu Kaur. Locker was drilled open on their request. The fact that the locker was drilled open and that no inventory was made prior to the directions issued by this honorable court would be evident from a statement of court.
Whether they are bound to make an inventory.
I'll show your lordship.
Okay.
Show your lordship.
But they have been able to persuade the bank official that they are the only legal
This
heirs.
is the letter of persuasion.
You
Page
go,
14.
you go against Sanjay Kaur. Why against bank officials?
Well, I have to go against somebody wherever I can recover
Sanjay Kaur.
The articles. Yes.
You have to go against Sanjay Kaur. Have you filed any FIR? I am not asking, or have you filed any FIR on the basis of these materials on record?
That I'll have to take steps in account.
Yes.
Against Sanjay also.
Sanjay has filed affidavit that he is the only legal heirs. There is a false statement before judicial magistrate. There are so many, and they have been persuaded. Yes, there may be latches on the part of the.
But bank
he,
cannot shirk
you,
its responsibility.
you did not proceed against Sanjay Kaur.
Well, I have to.
Have you?
Not yet. Not yet.
Because they are your relatives.
Well,
because the bank officials are not your relatives.
I'll show your lordship even from the.
Why you have not taken steps against Sanjay Kaur in spite of sufficient materials?
There is tremendous animosity between the family members. They cannot
Whatever
even see eye to eye.
Why you are after the bank officials?
Well, I'm after both.
Yes, they have certainly made some default, but there are sufficient materials. They have been.
Default. When I show you,
they are not advocates like you.
I'll show you. They have to follow RBI guidelines.
Yes, certainly. I am not saying that they are not at fault. But you did not take any steps against your relative.
Well, I have to take steps against both of them.
Very, very good criminal case would be there. I think. So many repercussions.
Yes.
False affidavit before judicial magistrate or then okay. So
this kindly comes,
this will help you to
whatever observation
keep Mr. Banerjee here. Yes. All these will go to show that Mr. Banerjee will be here. Serious issues are being discussed. Okay. Yes, you please complete.
Well, at page 14.
Page 14.
Yes. Well, this is the letter on the basis of which the bank claims to have acted. Lordship sees the date.
Please read.
20th November. Subject locker number 166G in the name of late Bimal Kaur. Kindly notes, names of others are not mentioned. Bimal Kaur to be transferred to his only legal heir, Mr. Sanjay Kaur and Mrs. Meetu Kaur. Dear sir, this is to inform you that the above mentioned locker was in my father's name, who expired on such and such, and the locker was being operated by late Jutika Kaur and late Shonda Kaur, both expired on such and such respectively. After the demise of both my aunties, the key to the locker was misplaced at our house, and I had applied before you to issue fresh key for locker number such and such. As I am the only legal heir of late Bimal Kaur, all necessary papers were submitted to you. I further state that my mother expired on such and such. I therefore request you to hand over key to the locker, and therefore, locker in my wife's name. All necessary charges for opening will be paid. So, the impression
affidavit has been submitted.
They have now filed an exception to the bank's report where they say the same thing.
No, there is an affidavit in 15.
Yes, I'm sorry. I stand corrected.
Your relative.
Yes, I'm sorry. But affidavit also saying the same thing, that Bimal had died interstate on such and such.
Yes.
And he is entitled to all movables and immovable properties of the deceased father.
Yes.
But my lord, the letter at page 14 is more incriminating. I'll tell your lordship why. Because my lord, this is gross suppression, an attempt my lord, to deceive and mislead. Because the impression your lordship reading this will get is that the locker was in the sole name of Bimal. And Jutika and Shonda were merely operating it. And therefore, keys were with them. Once they died, my lord, keys misplaced. And I being the sole legal heir, therefore, naturally, I'm entitled to everything. But question also arises whether the bank can completely turn a blind eye to its own records. Its records will say that Bimal is not the sole owner. There are joint owners. In fact, they have disclosed the locker opening form. Kindly, comes to page 17. I'm sorry, page 19.
But this affidavit, incomplete affidavit has been submitted. Why the second page was not submitted before me? Sir, you have to look into all these.
I don't know, maybe it's page 16. There is one page in between, 15A, I suppose it is the typed copy. Then page 16 is perhaps the second page.
Okay. Yes. Right now.
That save and except me, there is no other legal heir and successor of my deceased father. That
is correct.
That is all right.
So far as Bimal is concerned.
Because this is cyclo-styled affidavit that has to be filed in the usual course. Bank has asked for it, they have given it. 2 pages. But the letter at page 14 is incriminating.
Yes.
And we'll kindly see what the bank's records say. Page 19.
Page 19.
This is the locker opening form as originally filed. Possibly in 2006. The date is not very legible. Bottom right hand corner. Lordship will see the names at the top. Bimal Kumar Kaur, Jutika Kaur, and Shondha Kaur. The address is given. Towards the bottom, your lordship will find operating instructions.
Anyone
or survive. And my lord, the locker agreement, which is the very next page, page 20 onwards. My lord, clause 2 at page 21. 2A and 2C. Access to the safe shall be had by the lessee, or in the case of joint lessees, A, by either or survivor of them, by any one of them or the survivors or last survivors, and then kindly see C. Jointly by any of them or any of the survivors of them, or by the survivors or by the last survivor singly, or the duly constituted agent of a sole lessee, not employer, or of joint lessees together, provided such authority in favor of the agent be duly recorded in the books of the safe deposit department of the bank in case of death of the sole lessee, or in the case of death or surviving or last surviving lessee out of joint lessees, only legal representative, meaning thereby the executor or administrator of the deceased person, shall be recognized by the safe deposit department of the bank. So, my lord, here is a case where on the face of it, the bank has been informed that Bimal, being one of the joint holders, has died, is the first person to have died. So under no circumstances could the bank have been under any misconception that he was the sole or last surviving joint holder. I would have understood a case where there were 3, 2 have predeceased, and the legal heirs of the last surviving joint holder says that I am the rightful claimant. This is not even one such case. They don't even ask for any proof of death of Jutika or Shonda prior to Bimal. On what basis, if I may put my argument in question form, is Sanjoy and me too taken to be the legal heirs of one of the deceased joint holders?
Sure, they will start.
Just before they start, I'll just show the RBI guidelines on the point.
Don't worry, he will give it 6 minutes time, because
just your lordship, it has fallen from your lordship.
From 12 room, there is a fixed matter.
I see.
Okay.
Because it had fallen from your lordship, whether the bank was obligated to make an inventory just for that purpose.
Yes, certainly.
There is an RBI circular. I can find it. Lordship will this is of 18th August 2021. I'm sorry, my lord, I'm not carrying a copy, my lord, for Mr. Banerjee today. এটা নেটে পেয়ে যাবো। Safe deposit lockers revised instruction 18th August 21. সেই সময়টা ছিল। But I am relying on clauses 5 and 6. Particularly, my lord, 5.3.
5 and 6.
Yes, my lord. 5.2 begins with 21st August, 18th August 21. But the clause 5.2, if your lordship, my lord, comes straight to at page 7, it, my lord, deals with settlement of claims in case of death of a customer, which is, my lord, what we are concerned with. Now, my lord, your lordship comes straight to clause 5.3 under that heading.
5.3.
Yes. I'm placing that. If the sole locker hirer, my lord, not the case here, nominates an individual in the case of his death after verification of death certificate and satisfying the identity and genuineness of the individual approached, the bank shall give access to the nominee to remove the goods after inventory was taken in the prescribed manner. Even, my lord, in case of a sole. In case the locker was hired jointly, my lord, which is, my lord, our case, with the instructions to operate under joint signatures, and the locker hirers nominate any other individual in the event of death of any of the locker hirers, the bank shall give access of the locker and the liberty to remove the contents jointly to the survivors and the nominees after an inventory is taken in the prescribed manner. In case the locker was hired jointly with survivorship clause and the hirers instructed that access of the locker should be given to either a survivor, anyone or survivor, or former or survivor, or according to any other survivorship clause permissible under the provisions of the Banking Regulation Act, the bank shall follow the mandate in the event of death of one or more of the joint locker hirers. So, my lord, the same procedure. And then, my lord, 5.3.2. Banks shall, however, ensure the following before giving access to the contents to the nominee or survivor. One, exercise due care and caution by obtaining appropriate documentary evidence, make diligent effort to find out whether there is any order or direction from courts restraining it from giving access. 3, Malay, is important, make it clear to the survivors' nominees that access to the articles in the locker or safe custody is given to them only as a trustee of the legal heirs of the deceased locker hirer. That is, such access given to them shall not affect the right of claim. Now, my lord, comes straight away to clause 6.2.3. 6.2.3.
Yes.
Because your lordship will appreciate that breaking open of a locker is not something which is contemplated under any provision. 6.2.3 is the only clause which governs in what is to happen in the event of breaking open, which has happened here. The lordship has seen the affidavit of the bank, and the same statement also made by Meetu Kaur in her affidavit that the locker was in fact broken open. Banks shall also record a video of the break open process and the inventory assessment wherever legally permissible, and preserve the video to produce as evidence in case of any dispute or court or fraud case in the future. And my lord, one last clause, my lord, page 13, if your lordship is pleased to come to clause 7, which is the liability of banks, which has also been spelled out by the RBI. Banks shall put in place detailed board-approved policy outlining responsibility owed by them for any loss or damage.
7 point?
Well, it's 7, just 7.
Oh.
Under Part 7, compensation policy or liability of banks. Banks shall put in place a detailed board-approved policy outlining the responsibility owed by them for any loss or damage to the contents of the lockers due to their negligence, as bank owe a separate duty of care to exercise due diligence in maintaining and operating their locker or safety deposit systems. The duty of care includes ensuring proper functioning of the locker system, guarding against unauthorized access to the lockers, and providing appropriate safeguards against theft or robbery. Further, banks shall adhere to master directions on frauds. So, this is a case where I'm not even going to Sanjay and Meetu, because they have deceived the bank, made statements which are deliberate and misleading to give the impression that the certain facts were in existence which were clearly not. But the bank, my lord, ought to have, my lord, acted in line with the RBI directives, which were in vogue at the time when this was done. The locker was handed over sometime in or about, my lord, November of 2021. It was broken open. Not only was no video recording done of the breaking open process, no inventory was made, which is absolutely shocking. And the liability is clearly spelled out. And cut to the chase, Mr. Banerjee opened with. It is, in my respectful submission, it is the duty of the testamentary court to ensure, that the estate of the deceased is safeguarded. Because today I am only an executor. Well, today, even if the executor, it's a different matter that the executor and beneficiary are in the same person today. But if the executor were not to, even I put the accusation on myself, I have not filed an FIR against Ranjay and me. I ought to have, and I will. But the fact is, that the beneficiaries or the person who are entitled to inherit the estate, but they are solely dependent on the court, which is why this procedure was followed.
So you complete.
Yes, these are my respectful submissions.
Yes, bank. So we have a fixed matter from 12. So when? Tomorrow? Yes, no problem. The learned counsel for the executor has submitted that it is the responsibility of the bank to convince this testamentary court as to why they have allowed Mitu Kaur or her husband to open the relevant locker without permission of the court, or why the bank has why the bank has gone beyond the guidelines of RBI dated 18/8/2021. Stop. Para. The learned counsel for the due to paucity of time, list the matter. কালকে ডেটে দিয়ে দাও 3rd May for further hearing. Okay. Yes.
My lord, I am defendant number 1B. I am
Yes.
defendant number 1B appearing virtually.
Mr. Kothari, you are not present on the second call.
12 noon fixed matter, item number 20.
You are not present.
I was under the impression you
No. Second call was done.
apologies, Your Lordship. My
Not
bad.
today then. Okay.
Apologies, Your Lordship.
Item number 23 and 26.
My lord, may I take your lordship's 2 minutes of time?
2 minutes of time. Yes.
My lord, the application which is before your lordship, the GA 8,
I've forgotten
the
everything.
contention of the defendant number, substituted defendant number 1A is that the decree is unlawful and void.
এই আমার একটা নোট আছে। Yes.
The decree is unlawful and void. My lord, whether the decree is unlawful and void, this question arose before the appeal court in 2012. The appeal court held that the decree, there is no defect in the decree and the decree is not void and unlawful. My lord, may I just hand over the judgment to your lordship passed by the appeal court?
Please read the
Yes,
appropriate portion.
Yes.
Just I have to take the note. This is appeal filed by whom?
Appeal filed by the original defendant number 1.
The decree was challenged.
Just a minute.
Yes.
Last date who submitted? Mr. Bhattacharya.
My lord, I have not submitted. I have submitted that there is no substitution in the eye of law till date.
Yes.
No substitution application is filed in connection with this suit. And the only while this execution case was filed in the year 2014 February, my lord, first time the decree see the light of the court, there we found for the first time that the decree was not drawn up in accordance with law, since the deceased person's name has been shown as alive, that is defendant number 2, who died in the year 2008. On 16 June 2008, my lord, this honorable court directed for substitution to take steps by the parties. That was admittedly not done till date. Now, thereafter, my lord, it was filed, the decree was purportedly filed as if it was drawn up on 4th February 2008, and that too signed by not by the Honorable Justice Muharaj Sinha, who the Honorable Judge was pleased to accept the terms of settlement without going in. The decree was filed before this court along with the present execution case in the year 2014. Therein, that's why, my lord, in the year 2012, there was no question or issue whether the decree was properly drawn up or not, because that was not here nor there before the Honorable Division Bench in the year 2012. This was first time, and what has happened, my lord, while this execution case was filed in the year 2014, the execution petition itself shows in the page number 23, para number 17.
I think I have heard you. I want to know the last date who submitted. You have completed.
Yes.
Okay, just law point.
I would be submitting very gist. I would be taking only 5 minutes time. Let them finish. Rashik, kindly permit me to submit thereafter.
Okay, only law points. Yes.
Only law points. Only law points.
My lord, kindly take the judgment, paragraph number 11.
Appeal order.
Yes. Appeal from recalling of the compromise decree.
Paying for recalling.
Yes, recalling of the decree by the original defendant number 1.
At the instance of original.
Yes.
Instance of. What is the name? Original defendant number 1.
Yes.
What is the name?
Pran Kumar Bhattacharya.
Pran Kumar. Yes. Read.
My lord, paragraph 11.
Yes.
The defendant number 1 had preferred APOT 106 of 2011 against the decision of the learned single judge dated 7th March 2011. Disposing of GA number 1361, this is, my lord, the recalling. GA number 1493 in terms of the order passed against the appeal court on February 2, 2011 in APO number 423 of 2010. Thus, the present appeal. The division bench dismissed the appeal, finding there was no scope to interfere with the impugned order passed by the learned single judge. Thus, order dismissing the application to set aside the compromise decree was confirmed. My lord, then paragraph 15.
Fifteen. Yes.
Before we proceed further, it is necessary to note that GA number 1493 of 2009 was filed for setting aside the compromise decree dated 19 December 2007. It was dismissed by the order of the learned single judge passed on 7th March 2011 in terms of the order of the division bench in the present appeal. An appeal was filed by the defendant number 1 being APOT number 106 of 2011 to challenge the order dated 7th March 2011. That appeal has been dismissed on 21st March 2011. Therefore, question of setting aside the consent terms does not arise. The only issue which is relevant for our consideration is whether the order passed in the review application is incorrect. Then, my lord, 18. My lord, the defendant number 1 submitted that the decree should be re-examined and reconsidered. Then the court held the submission of the learned counsel are untenable. The order of division bench dated 8 June 2011 must be read in the context of its earlier orders. The order does not, in our opinion, mean that the question as to whether the compromise decree is unlawful can be reopened. All that the division bench has observed that observed at the interim stage is that the issues arising in the appeal should be re-examined and reconsidered so that the interest of that appellant number 1 are protected. My lord, the defendant number 1 was the appellant. These observations was made because of the contention of the defendant number 1 that the building plan submitted by him cannot be sanctioned in terms of the existing law. We have considered the prayers in the present appeal, which is directed against the order of the learned single judge dated 14 September 2010, refusing to review the earlier order passed on 27th August 2010. The order dated 27th August 2010 directing the submission of a plan to the municipal authorities was an interlocutory order passed in GA number 2944 of 2010. The interlocutory order passed on 27th August 2010 has not been challenged in the present appeal. Apart from this, the issue as to whether the compromise decree is unlawful, my lord, kindly mark it, unlawful has been put at rest with the dismissal of APOT 106 of 2010 by the division bench. My lord, therefore, my lord, this points, my lord, cannot be taken in an execution that the decree is unlawful and void and cannot be executed when the same was confirmed by the division bench in 2012. And my lord, then section 47 was filed by the original defendant number 1, that too was dismissed. My lord, may I hand over that order? Dismissal of section 47. It is in record, my lord. Your lordship's convenience, I am handing over the order. Thus, by confirmation of the decree by the appellate court and subsequently dismissal of section 47, no such point can be taken by the substituted defendant that the decree is unlawful. No SLP was preferred from the appeal. I have handed over to your lordship. And my lord, no appeal has been preferred from the dismissal of section 47. So, re-examining and reconsidering whether the decree is unlawful cannot be agitated, my lord.
That's all?
Yes. Apart from that, my lord, explanation 7 to section 11 says, my lord, that res judicata is applicable to the execution case. Apart from that,
yes,
explanation 7 to section 11. Apart from that, my lord,
you have mentioned this. So
yes.
I think.
Apart from that, my lord, your lordship knows, my lord, the executing court cannot go behind the decree.
That's all.
Yes.
My lord, may I reply?
Is available to them is by.
No, I think this is the defendant number.
Yes, defendant number 1A.
1A has the right before you to.
My lord, because the submission made is not correct, my lord, in my respectful submission. Lordship, kindly excuse me.
I said here, but after Mrs. Mukherjee.
My lord, Mrs. Mukherjee would be submitting on the fraud committed upon the court, but the order referred by the plaintiff right now is not perhaps correct. If your lordship kindly sees the execution petition itself, because I am not standing in the way of Mrs. Mukherjee, because I am supporting her. So, my lord, the submission right now plaintiff made, perhaps not correct. Lordship kindly comes to execution petition for the first, because I didn't get the opportunity to submit on this court, which I have submitted before the Honorable Appeal Court. Lordship kindly once come to the execution petition.
No, what happened, Mr. Bhattacharya? I have a fixed matter on their submission yesterday.
Then, my lord, okay, my lord. Then I am not. Lordship, kindly recall that I would be replying to the plaintiff's today's submission.
They will, yes, they will take.
Then Mrs. Mukherjee, let Mrs. Mukherjee submit, my lord.
And Mrs. Mukherjee will take 10 minutes time. So 12-minute times are allotted, but it is now 12:15.
Fixed matter is at?
For examination of judgment debtor, for examination of judgment debtor. So when you will come back? After recess?
Come back after this.
Oh, fixed is it? Oh. পড়া যাবে না। So Monday? Monday, okay. The learned counsel for the decree holder has completed his submission on points of law. Stop. The learned counsel.
I'm sorry to interfere.
The learned
Next-
counsel. I have to dictate. I am dictating.
No, your lordship is dictating because the witness has not come, the fixed matter. That's what I'm indicating.
Okay. Then I can take up.
Yes, that's what I'm saying. I'm
Okay.
sorry to interfere, but the witness has not come again.
No, then I have to adjourn that matter also.
Yes.
What is your other side?
Yes, clear. That's why I
expired last week.
three times they are not coming.
It is my fault. My mother-in-law expired last week.
So you please come on Monday. Okay. That would be helpful for you. Okay, just লিখে নিন Mrs. Mukherjee appearing on behalf of defendant number 1A only. And Mr. Bhattacharya.
Pratik Bhattacharya, defendant number 1B.
Defendant number 1B appearing in person will submit
In virtual mode. In virtual mode, my lord.
On virtual mode লিখে রাখুন তো ব্র্যাকেটের মধ্যে ওনার নামের পাশে। Everybody is everything is you are not complying with the timeline. Oh, পরে
On the last occasion, everybody has completed.
কি বললাম বলুন তো?
Reply today.
On virtual mode, okay, on virtual mode, we'll submit on points of law on Monday. You come back on Monday, we say, Aisha.
Grateful, Lordship.
Monday, okay.
Grateful to your lordship. Grateful to your lordship. My lord, item 23 and 26 analogous matter.
Okay. দুটো দেখে দেবেন।
Grateful to your lordship.
Depositionটা থাকো তো। Then I shall take appropriate steps.
Well, 15 fixed matter. Item number 9.
Yes, what happened?
Again, the witness has not come.
Whose witness?
My fault, my lord. I am
Your fault.
Yes, my lord.
Why?
My mother-in-law expired last.
Your mother-in-law expired.
My mother-in-law. It was not possible for me.
When she died?
24th April, my lord.
24th April. And when the last order was passed?
Last 27th March.
Lord,
No, not 27th March. 13th April.
13th April.
1 week ago, that person came returned from Chennai after Easter.
No. After when I have passed this order on 13th April, I think you should have informed him on 14th April.
My lord.
Whether you have informed.
Yes, my lord. I informed.
I shall pass this order.
After returning from Chennai,
yes,
got only 4 days time, my lord. It was not possible immediate in the meantime.
No. He's a judgment debtor. I think I cannot. I have to go through the record first. Whether you have given sufficient time on earlier occasions.
Yes, madam.
No. I have to issue then.
This is the third time.
The learned counsel for the judgment debtor has again sought for accommodation. I am giving you on your instruction or on your prayer. I am fixing this matter on 12/15.
My lord.
Okay.
My lord.
Then
my lord.
The Lord has submitted that he needs 4 weeks time, as Mr. Lakotia has got spinal injury recently.
My lord.
Who is Mr. Lakotia?
Who is the witness?
Who is the witness? So I have given you time.
But allow me as a last chance, my lord.
Learned counsel has sought for an accommodation for no. I have to pass.
After
No.
5th May, my lord. After 8th May, allow any day.
Why? What do you think? This is a very easy matter to get accommodation from this court.
No, my It is my
No,
personal.
no,
because
I am accommodating all of you, giving time, fixing a specific time. In spite of that, you are taking time.
I am a pretty unconditional apology for.
Unconditional, conditional apology should be done. Not unconditional. It is long ago. It has lost its anything, influence or anything. Unconditional apology. Conditional apology. You pay some amount to the legal aid council. It will helpful.
If your lordship
So desire.
pass an order, I have nothing to do. But is it on my personal difficulty? It does not.
This is a personal difficulty, maybe right, but your record shows that you are time and again you are paying for time,
sufficient.
and I have fixed a specific time for examination, leaving aside all those matters. Don't you think that this is a very serious issue that I am fixing your matter by giving a specific time? You have to understand the importance of the matter and fixing of the date and time. A Monday koro. Yes. Time fixed. 3:30.
Can it be Tuesday? Monday,
Yes.
I have got a fixed Tuesday.
3:45.
Yes.
Tuesday. The learned counsel for the judgment debtor has again sought for accommodation due to his personal difficulty. Stop. List the matter for examination of judgment debtor on কত তারিখ হচ্ছে 7th May at 3:45 for examination of the judgment debtor.
Well, item 10 also connected, two execution applications.
Okay.
Grateful, my lord.
Item number 17.
My application.
Yes.
This is an application for inventory of the locker and for amendment of the affidavit of assets. Initially, there was this is GA2, my lord.
Yes.
GA1, my lord takes up the order dated 18 July 2023 passed by His Lordship Honorable Justice Mukherjee.
এই দেখি কি আছে
May I read the order? This is an application by the executor who had filed the application for grant of probate being PLA number such and such to open a bank locker bearing number such and such at Andhra Bank, Ejra Street branch, Kolkata. The particulars whereof are mentioned in the will itself. Please submitted that the Andhra Bank is now as Union Bank of India at the Ejra Street branch. Andhra Bank is now the Ejra Street branch of Union Bank of India. This has gone down with wrongly, my lord, the order. That's why we have filed the GA2. If my lord takes up GA2, the page at page 17A.
So this is a mistake committed in the
In
order.
the application GA1. GA1 affidavit of assets, there was a mistake, typographical mistake that the order has, the bank account locker details were given wrongly.
Because you have given wrong address.
Wrong address, my lord. The order had gone down wrongly. That's why we have
No,
filed the
on the basis of your petition.
of my
So you have incorporated wrong address.
That's why we have filed the seven.
So you should say so
My lord.
that I have committed mistake in my petition. That's why the court has passed this order.
Thereafter, we have filed the GA2.
I have to pay. You have to pay. Your client has to pay for this amendment. Okay.
My lord, if my lord takes up GA2 page 17A,
J2
page 17A,
17A.
the typographic, the typed copy, this is the bank account locker details, my lords.
Para
My lord, page 17A. the
17A. Sorry.
annexure.
Annexure.
This is the bank account details locker.
17A or 17B.
17B is the typed copy, my lord. 17A is With the type copy.
So why it was not placed before the earlier bench?
It was not placed before the, it was, matter was.
Committed mistake.
The matter was appearing before his lordship. My lord, my advocate on order failed to appear. She had an operation on that.
No, whatever it may be. I want to be, you have, there's a wrong recording in the order. Why? The wrong recording on the basis of, so you have to pay the cost for amendment cost. Okay. You have to pay to the legal services authority. So what can I do? Now your initial sufficiency should be otherwise. Yes, you tried to put this matter on the soldier of the court. Yes. That is why I am taking exception. That is only thing, nothing more than that. You have to be very fair.
I have a copy of GA1 that is that was mentioned in paragraph 10 also. If my lord takes up my GA1,
yes,
it was mentioned in paragraph 10 that your applicant humbly submits that, a direction be given upon the branch manager under bank Koikhali branch, now Bank of India, make proper inventory in respect of the goods lying in locker as mentioned in the last will and testament of 16th August 2019. And that was mentioned in my paragraph in GA1. If my lord takes up my GA1 once,
এই দেখি জীবন কোথায় আছে disposed of, তো দেখবো কি করে?
I have a copy of the GA1, my lord.
Yes.
GA1. This is my copy. It was particularly mentioned.
যাই হোক।
That's why I have.
Yes, tell me.
10, my lord.
Paragraph 10.
Paragraph 10, if my lord take.
That direction be given to the bank manager of Andhra Bank, Koikhali branch, now Bank of India, make proper inventory in respect of goods lying the locker, as mentioned in the last will dated at.
Order records that the bank, Union Bank of India, Edra Street branch, my lord. My lord takes up the order dated 18 July 2023.
At Andhra Bank, Isra. Andhra Bank, Koikhali branch. It has been mentioned in your petition.
Correct the order, my lord. Record had an operation, operation. The matter was appearing before his lordship, Honorable Justice Mukherjee, and the matter had gone out of list. That is recorded in the order dated 10th October 2023.
So this should be Ejra, Andhra Bank, Koikhali branch. This only Koikhali branch. B56 is there.
Yes, that is the locker number.
That is okay.
That is correct.
For correcting this order, you have to file a GA2 because GA1 has been disposed of. Oh. Now, why is your prayer in GA1?
GA1, minor, that is in the master summons, man.
Yes, show me the master summons.
Master summons are.
What is your, you come at page number 2.
Page number 2 of my GA1.
GA1.
Page number 2, my lord.
Yes. Para 8.
Para 8. Your propounder further submits that
please read loudly so that I can.
Propounder further submits that unless the inventory made in the proper manner, propounder may not be in a position, even in proper details of the goods lying in the bank locker 856 B56, which is lying in Andhra Bank, Edra Street, Koikhali branch.
Edra Street, who incorporate?
My lord.
So you mentioned. Then you try to save your junior, but you are unable.
Paragraph 10, my lord, it's clearly.
I have enough time. Tell me.
Paragraph
it is your mistake. Unless you admit, I shall not allow. That is your mistake. Mistake may be committed by court also.
That's the fact. That's the fact. My lord.
The learned counsel for the petitioner has submitted that due to oversight, the bank address in the order dated 18th July 2023 has been mentioned as Andhra Bank, Ezra Street Branch, Kolkata, which should be read as Andhra Bank, Koikhali Branch, Kolkata. That is sufficient?
Yes.
Stop. Para. Perused, considered. Let the order dated 18th July. Only one.
And the master summons, the prayers may be allowed, my lord. My lord,
The order dated 18th July 2023 is to be rectified. Stop. The address of the bank where the locker bearing number B56 is lying should be read as Andhra Bank, Koikhali Branch, Kolkata, instead of Andhra Bank, Ezra Street Branch, Kolkata. Stop. The leave is granted to make necessary correction in the master summons.
Master summons has been correct.
Correct.
The master.
তাহলে এটা দিতে হবে না লাস্ট
And we would make the inventory of the locker in presence of the branch manager and the department and the affidavit of assets. If my lord takes up the master summons paragraph prayer A, B, C, D, and E.
let there be an order in terms of prayer A to C.
D. We have reaffirmed. We have to reaffirm the affidavit of assets.
D. A to D করে দিন A to D. The GA number 2 such and such is thus disposed of. So this is your mistake. However, he has undergone gallbladder surgery. I have to consider. What happened?
Item number 18.
So many.
This matter, there are two GAs appearing before your lordship.
17.
18. One is my lord, the
Yes,
GA
17 is 83. Okay. Yes.
in GA, in item number 18, there are two GAs. GA1 of 2023, my lord, is my application praying for revocation of probate, of grant of probate.
Revocation.
Revocation.
You use 6 revocation.
Revocation of grant of probate.
Who was the?
Please, your lordship, I'm
They are the
appearing for
performers, my lord.
the
In
petitioner.
my application, my lord, the pleadings are complete, my lord. I have filed my opposition.
What is your number?
My lord, my number is, my lord, GA1 of 2023. And item 19, my lord.
And 19.
And
GA
19
2.
is same matter, my lord.
GA2.
GA2 of 2024. That is their application, my lord,
For?
where they are seeking extension of time, my lord, to file their inventory, my lord.
Oh.
And accounts.
Your lordship is for
Within 6
inventory
months
and
they have to file.
accounts.
Within 6 months they have to
It's been
file.
over 20 years.
20 years.
Your lordship, we filed an application to seek leave for filing the inventory and accounts.
In fact, that is one of
Why shall I grant after 20 years?
Your lordship, your
the last
lordship,
occasion. Lordship-
Allow him to speak. Yes.
your lordship, our client was not advised before, unfortunately, your lordship, to
No, I
file
am
the
not. I am not anything about you
so-
personally. I am saying about in respect of your client only. Why he has taken 20 years time to file inventory.
Your
Now
lordship,
see what happened. A
the
petition
directions
for
were given
revocation.
to file affidavits, your lordship, in the last occasion.
You have to show that I can allow you that I can allow you to file inventory after 20 years.
Your lordship, the application was moved in the last occasion and
Last
directions
occasion
were,
when? 24.
directions were given for filing affidavits, your lordship, for on 21st March
This is a very peculiar thing.
2024, your lordship.
I'm out of time, my lord. To
No, he has prayed for revocation. He has prayed for revocation. That matter should be heard first. Then I shall allow your inventory.
But your lordship has already given directions, my lord, on the last.
I am withdrawing. That can be done.
My lord will only give a short extension to my learned friend, my lord. Both the application can be taken.
Learned counsel for the just a minute. এটা লিখতে হবে না. The learned counsel for the petitioner has filed this application, praying for leave to make an inventory and file the accounts. Have you mentioned at that time that I am going to file 20 years after? Have you made this submission before me? That it,
The application was heard by your lordship and then directions were given for filing.
so why
Explanation, my lord, has been.
the learned appearing for one Assis Join wants to file affidavit in opposition? Who is that?
That's me,
My learned friend.
Mr. Mr.
Medora.
Medora, sorry.
That's the
Medora
difficulty if he's
is
on the other
given
side.
liberty to file affidavit in against the application for the within that you have been given time to file.
An opposition to their application.
Oh,
my lord.
have you submitted?
No, I'm praying for a short extension to file.
Oh, so I have to
Mr.
hear.
Mr. Medora himself had asked for that.
Oh, so I have to hear. Then it is okay.
That's the difficulty, my lord, if he's there on the other side, my lord, because very
Yes.
difficult for us to match up to him, my lord.
Why?
Very difficult.
Why?
Because it is.
But I hope I enjoy some special equities with Mr. Mukherjee.
Mukherjee.
There's one more Mukherjee. my lord.
Oh, all Mukherjees are here. Okay, so I can give you 1 week time. The
I'll
learned
take it
counsel.
2 weeks, my lord. We'll come back.
Why? Then 4 weeks.
The client is
5
in
weeks.
outside. That's the only difficulty. She's based in Delhi.
My
my
lord,
lord.
kindly keeps it on the reopening, my lord, anytime. Because, my lord, I'm being led by Mr. Dev, my lord. He's not there from 13th. 13th of May, my lord. He's not
Oh.
there, my lord.
Okay,
Anytime after the reopening.
Mr. Medora.
Yes, my lord. It's a Parsi surname, my lord.
Very good.
My father's a Parsi and mother's a Bengali.
No, my pronunciation is not very good. Mr. Medora, the learned counsel for the opposite party in GA2 of 2024 has sought for an accommodation, has sought for an extension of time to file affidavit in opposition. Stop. He is given liberty to file affidavit in opposition within 2 weeks or within 1 week from date,
Can you make it 10 days, my lord?
10 days from date.
I'm ready.
Affidavit in reply, if any, be filed within 7 days thereafter.
My lord will also give me 10 days, my lord.
Then it will be no problem, no? Even if there is a summer vacation.
My lord, the difficulty, my lord, Mr. Dev won't be there. My lord will request you to keep your lordship on the matter.
The affidavit in reply be filed within on reopening day. On reopening day after summer vacation. Stop. List the matter for hearing on. দেখো তো একটু রিওপেনিং এর পর হ্যাঁ না 10th নয় রিওপেনিং ডেতে ওরা ফাইল করবে অ্যাফিডেভিট ইন রিপ্লাই 7 days করে দাও 17 June.
Most grateful to my lord.
Both the matter, okay?
Both the applications.
So I have to record the same thing. The late GA1 of 2023 also appear on 17th June for hearing as pleadings
Yes,
affidavit
pleadings in that is completed.
as the pleadings are complete in that case. Okay.
17th may be a holiday, I'm told. Maybe.
17th.
Maybe a holiday.
So then 18th? 18th? Okay. Huh.
Special quickly. Second year.
You know the holidays, no?
That's my lord. What my learned friend
Holidays,
submitted sometime back. Special
Post
equity.
holidays, everything. Okay, very good.
Be well informed by that.
But
For
there
your
is a
lordship in particular.
working Saturday.
That is coming, my lord, in June.
When?
29th
June.
29th of June.
I shall fix all matters on 29th. No, I have to
We'll
work.
create history, my lord, together.
Yes. Okay. Very good.
Gratefully.
Item number 21.
My application, my lord. Only one indulgence, your lordship. The advocate on record is not well.
Yes.
The advocate on record, your lordship, is not well, Mr. Manoj Tiwari.
Oh.
There was a direction to file an affidavit in opposition. Your lordship, I'm praying for 2 weeks' time. Your lordship.
Very innocuous prayer, my lord. In their affidavit of asset, my lord, they have said existence of certain shares, my lord. Now everything is gone.
Go on, my lord.
So it's seeking for accommodation for advocates ground.
My lord, I shall not oppose on that.
The learned
my-
counsel for the defendant.
Respond. Plaintiff, my lord. This is an application for your lordship for regarding appointment of an
So
administrative.
you are the plaintiff.
Lordship, I am
Plaintiff respondent
for the defendant, my lord.
has sought for an accommodation as his learned advocate on record
Yes.
is indisposed of. Stop. Please see matter after 2 weeks at a date the under the same heading. Okay.
Affidavit of opposition, your lordship, time may be extended, your lordship.
The opposite party, the plaintiff respondent, plaintiff respondent is at liberty to file the affidavit in opposition within 7 days from date and affidavit in reply within 3 days thereafter.
Yes.
Affidavit in reply, if any, within 3 days thereafter.
Great.
Okay.
Item number 22.
Hey, not today, Kodadi?
Not today. Item number 24. The third day, perhaps we are
So
it's not coming.
that's the lady, no,
That
who
lady and
was appearing in person.
he was only making a claim for the extra amount which according to her she entitled to.
I think last orderটা কি হয়েছে একটা শোকজ করে রাখি
Division.
so I have to dismiss.
We have offered, we have made the calculation, we are offering the money, she is not willing to take up.
Now if she does not appear before me, what can I do?
Yeah, only thing we will only kindly make some observation. Whether this cannot go away this way. Hard day we are appearing.
None appears on behalf of the petitioner. Stop. Learned counsel for the KMC Employees Cooperative Society is present. Stop.
It is also being present. All respondents are
Okay,
present.
all are there. The learned counsels of all the respondents are present. Stop. Para, it appears that this is the second day, I think.
Third day, according to my Milord noting, 38th Milord
Third day.
it was hold on 30th 4th.
And this is the third day.
Again
na,
on
bolam?
first May,
This is a
and today is the third day.
This is a consecutive third day when the petitioner does not appear. Stop. From the record, it appears that the petitioner Kiyakor, Srimati Kiyakor was appearing in person. Stop. However, for ends of justice, the petitioner is directed to submit a show cause as to why the instant writ petition shall not be dismissed for default.
Last chance.
Last chance.
Instead of so
This is not possible. কি বলুন? The petition is directed. No, এটা কেটে দিন. They list the matter
And
for
Milord,
hearing as a last chance. Okay.
and Milord, one indulgence I will be praying, Lordship. Since Milord, our authority have decided, their management has decided that she is entitled to certain amount. Ultimately, Lordship be kind enough, if it doesn't come, liberty to the authority to
On that day, I shall.
send the amount without any prejudice.
Okay.
And matter may be disposed of.
Okay.
At least
Come on that day.
let her get some amount also.
Okay. When it shall be fixed? After. Huh?
next Thursday. Next Thursday. And then your lordship kindly also direct the register to communicate the petitioner.
আচ্ছা ওটা whether this can be done
Milord, let it be fixed on Monday.
this Monday.
This Monday.
She has to be below 16, she is appearing personally, not from monthly she is appearing.
So she should be given at least fortnight time.
Hard day, she is not appearing.
She should be given
The present
at least she should be given 10 to 15 days time to appear. Otherwise, I shall.
Only thing, my lord, some information maybe Fandi give it to her.
আরে আসুন তো লিখে দিই
Taking up this matter such and such date. You know, register original said.
একটা ডেট দিন তো 15 দিনের আপনারাও দেখেন প্লিজ গো থ্রু ইয়োর ডায়েরি 16th May
In the meantime, you know, register original said.
এটা লিখে দিন এটা the learned registrar original side is requested to communicate this order to the writ petitioner in her postal address. Okay. Stop. ঠিক আছে লেখা হলো ঠিক হয়তো কারেকশন হবে কি হবে জানি না
And my lord, kindly observe it as last chance.
হ্যাঁ I have mentioned
And last chance
I mentioned as last chance
for
for hearing as
for
last
passing appropriate order.
for passing appropriate order লিখে দাও
Lordship.
1245 fixed matter, item number 11.
Yes.
25 both parties are people not take
25 25 why is it 20 what happened
Your Lordship kindly sees the last order of the 8th March. Your Lordship was pleased to direct the department to mark it as contentious matter. But Your Lordship, instead of 4 weeks as granted by Your Lordship, 8 weeks have passed by. It has still not been marked as contentious and
Hey,
the
কি
suit
হয়েছে
is
এটা
not
দেখো
proceeding.
I'm looking up there's an order passed by me
Yes, Your Lordship.
Yes, yes, my lord,
The
it was on
petitioner
এই
is
দেখো এটা কেন হয়নি
March.
মিস হয়ে গেছে কোনো কারণে এটা দেখো আর অর্ডার করতে হবে না ওদের ডেকে বলে দাও কেন হয়নি এটা I have to pass any order
Your Lordship does not possibly require, but
That's
rather
not
the
that.
petitioner has to file an application to
Okay,
get it marked as contentious.
hey
Your
দেখে নাও
Lordship kindly
who is for the other side
My lord, I'm for the applicant.
you are for the applicant
My lord, one
Your Lordship.
indulgence, my lord. My lord, my learned friend has already served a copy of the evidence in support of caveat upon us. We want to take an exception to that caveat.
you can
That liberty, ma'am.
Your Lordship, let it be marked as contentious. Let them take steps.
okay
In the
They
meantime,
cannot.
you come up at
Your
2 p.m.
Lordship,
at 2 p.m. I shall
the petitioner is not taking any steps. Basically, the petitioner is a
not this
complete
week not this week okay
this
it will be helpful for you okay এই এর মধ্যে করে নেবে not this week করে রাখো ঠিক আছে যা করা করবে ওই দিন আসবেন I shall pass
kindly
this.
fix a date so that we can.
not this week means Monday এই এটা দাও এক্সামিনেশনটা
Twelve 15 fixed matter, item number 11.
Witness is present.
witness is present you are crossing the examine Mr. Dasgupta you have now sufficient time till 1:15 so I think you have almost completed no
Milord, if I get my answers, Milord, I'll complete. What, Milord, I don't have any fascination for being witness. I will get my answer, I'll immediately stop. But if I require something,
he is not your student you may put questions but you are not
yes, then I'll have to continue, Milord, till I get my Lord knows.
Will the witness be permitted?
Yes,
yes.
He's already on.
এই আগের দিনের রিপিটেশন প্লিজ ডোন্ট রিপিট ওকে
No, I am on the fresh documents given by them last day. I will recollect. Last day, witness shown the document handed over by the judgment debtor on
April 15, 2024. এরকম একটা, হ্যাঁ।
তিনটের সময় কি বিষয়? তিনটের সময়
প্লিজ কাম টু
দুটোর সময় কি আছে? Yes, yes. Oh, those are arguments. Yes, yes, please.
Please come to the second page. No, first page. Very well. Mr. Bengani, so I take it that whatever has been certified is true and correct. Whatever is been written in the document and the contents of the document are true and correct.
Correct.
I put it to you. Okay. Kindly come to second line and the third line. It mentions about payment of sum of rupees 5,95,000 by you through various bank transfers to Mr. Virendra Singh Bengani, who is your advocate. Kindly tell my lord that what are the details of these bank accounts from which you have transferred a sum of rupees 5.95 lakhs to Mr. Surendra Singh Bengani, to Mr. Virendra Singh Bengani.
बैंक अकाउंट का डिटेल्स सब बताइए, जिस बैंक अकाउंट से आपने ट्रांसफर किया है ना, बैंक अकाउंट का डिटेल्स बताइए।
डिटेल मेरे को याद नहीं है, तो इतना उम्र हो गया, कैसे याद रहेगा इतना पुराना बात?
बैंक डिटेल्स राइट नाउ, बैंक डिटेल्स राइट नाउ।
So kindly bring the, will you be able to give the details on the next day?
नहीं, मैं और नहीं आ सकता यहाँ पर, मैं बीमार रहता हूँ और 73 years old हूँ और बहुत सारी बीमारी है।
I am not seeking very well. Kindly see the demeanor of the witness. Kindly watches this demeanor, body demeanor of the witness. I have never seen Miller this kind of witness. With deepest of respect, and Mr. Banerjee will also support me in that. Kindly see the.
Are you supporting him?
He can't oppose. He can't oppose the body demeanor. Opposing. He should control his client what to say.
His demeanor will appear from his answer. Don't worry.
I must only indicate, just for expedition, that he has already disclosed his bank accounts.
Where?
His affidavit of assets.
There is nothing in those accounts. He has said.
Yes, very innocuous question. Whether
And it is more innocuous that this affidavit is on record, which says that whatever he has said is true.
answer is different.
He's asking
I will
about
not. I will not be able to
this is
come.
already on board. And it's a repetition in that sense. And if the
My lord, he has deposed that 800
please
rupees in that account. If he has 800 rupees in there, how can he pay 5.95 lakhs in the financial year of 23-2024? I am asking the question, but this can't be the body demeanor of a witness, then I can't come from the next occasion.
His answer will reflect his demeanor. Okay, please take your seat, Mr. Banerjee.
I put it to you that you will bring the document on the next occasion, so whatever will be directed by this honorable court about the transfer, details of the transfer and the details of the bank accounts mentioned here.
तो मैं भेज दूंगा, मैं बाय कुरियर भेज दूंगा इनको लिख करके।
I will send this by courier to my advocate.
Kindly come to the second page. Apart from serial number B, which you have transferred to your advocate on record, you have also transferred a sum of rupees 5,20,000 and 3,10,000. Am I correct?
Correct.
How have you transferred this amount?
कैसे ये अमाउंट ट्रांसफर किया है?
ये स्टाम्प कोर्ट फी खरीदने के लिए तो कैश रुपया जमा दिया है।
I have given this money by cash.
हम्म।
So I take it that a sum of rupees apart from 5.95 lakhs, a sum of rupees 8 lakhs has been paid by you.
हाँ।
So I take it that the aggregate sum of rupees 14,25,000 as given by you, as has been furnished by you, is true and correct?
हाँ।
Mr. Bengani, what is the make of your shoe that you are wearing today? What is the name of the company that you are wearing today? The shoe?
पहना है ना,
हाँ।
किस कंपनी का है?
स्केचर्स।
What will be the Skechers? So, as you are using as you are using a footwear of Skechers, so I take it that you have sufficient money to purchase a footwear having a make of Skechers.
आपको बताया जा रहा है कि आपके पास
You are giving opportunity to.
मानी है Skechers
Why this second question
नहीं,
is
मैंने ये खरीदा नहीं था, मेरा लड़की ने मेरे को गिफ्ट किया था 4 साल
why you have put this question?
not purchased.
4 years back.
We'll let him give the bank account details, Millard. We'll come back next day. Let him kindly put it any day. Millard.
Sir, only 2 or 3 questions.
What can be done, Millard?
Other part?
Other part I am over. Let him give the bank account
Only,
details.
just
Only this portion, bank account details. Millard, I'll.
there is a very heat wave is going on. Shall I put
After
it
heat wave?
after
Yes, after heat wave.
summer vacation?
Yes,
Okay.
yes.
It will helpful.
I am being told that in Delhi, Millard, the weather is better than us.
Yes, that is true. Delhi,
Oh.
fortunately, is having a cooler temperature. It is not touched 48. Let him enjoy that a little more.
I'll lick him later.
In the meantime, if it is only restricted to that, and my learned friend Millard is all entitled to ask questions on production of new documents, we will take steps if it can be conducted through virtual medium.
No.
We'll take steps. That's why I'm not saying. I'm
No, I'm
not
opposing.
asking for any prayer.
That is
After
Let me
summer
speak to
vacation,
my client. Let me speak to my client.
we are going to
Why
fix
the-
after
why-
summer vacation. It will help also your
After summer
witness.
vacation?
I'll try to impress upon him. Whatever is the law with respect to VC
A
matters,
witness having this demeanor?
I am ready.
No, Millard,
Courts are doing it.
No.
This is not a.
Let him show any court has done this in this.
मेरे को
No, I'm not saying anything.
My lord,
Yes,
मेरे को
actual mode of taking evidence is going to be allowed very soon. Or
No, it is being.
it is.
Kerala High Court has very well.
एडवोकेट क्या बोलेगा, मैं बोलूंगा।
He is full swing in it.
हाँ।
The Supreme Court, our Chief Justice of India, is
Yes.
a great supporter and promulgator of it. So
Yes.
we are aware of
And it will be helpful for us when you will be in decree holder's position and when we will allow
Will
this.
change the position.
No, I do not mind because
No, I am ready to. I am ready.
questions will be heard by
Okay.
everybody through virtual.
Okay.
It has a paraphernalia.
Okay.
What happens if somebody provides him the answers in the virtual mode? Can we see what is there behind the laptop?
It will be on oath. There is a reason
अरे
why
वो तो तेरा
people
आजकल
say
किच्छु नहीं भाई.
No, we can allow subject to the matter
no.
that if all parties agree.
I'm not agreeing, Millard. I'm saying Millard here and now.
Just see, let me. If he can come, he has already expressed his difficulty. if he is in a position to come, I'll definitely try to impress upon him to come, and he has to come.
Okay,
The lordship's
he
order-
should not forget that he is a decree holder
Yes.
and his appeal decree judgment debtor and his order has been upheld by the division bench. So as on date, he should not be given such latitude. And looking at the
If it is possible to, after instruction, he may come in the second half or tomorrow.
Lordship will fix tomorrow morning. He can come.
He
In the
can
meantime,
come.
Milord,
let him produce. I'll ask
Yes,
him tomorrow morning.
that will be helpful.
kindly keep this tomorrow.
Tomorrow.
Let us see if we can.
10 minutes time is sufficient. If
I will have to
certainly.
let him give in advance. I'll consult my client. If it is done, I'll ask
Lordship
questions.
will kindly keep this matter tomorrow at around 2:30, so that we are in a position. If it is commensurate to your lordship's list, we will be in a position
Yes,
Milord,
yes,
to produce
yes.
the documents by 10:30 or by 11 in the morning, so that Mr.
Milord,
Samuel
I am making it very clear. I'll be requiring the bank accounts details. I'll be requiring
Bank account details.
where from where he has made this. I'm making it clear. So tomorrow if he comes with 2 page or like last days, then it will be difficult. I'm putting him on notice. I'll be asking for the details of the bank accounts because he has said by bank transfer. Number one, number two, I'll be requiring the bank statement of those accounts. So if I can get within one night, I have no difficulty. In fact, it was my lord's order last day.
will keep it. Even my advocate on record is saying that he has to take proper instructions. We'll keep it at a breathing
The
space.
examination of witness such and such is resumed and he has been examined in part. Stop. At this stage, the learned counsel for the decree holder has prayed for a direction upon the witness to produce the necessary bank details as per his statement today before this court.
Bank details given with regard to the documents, I'll just give.
Bank details regarding with regard to document বলে যেটা বলবেন সেটা লিখে নেবেন। This is the matter. After summer vacation একটা ডেট দাও। डेट डायरी टाइम सब देखे नाओ।
Yes. मेरे को कुछ बोलना है।
बोलिए।
मेरे को आने में बहुत तकलीफ होता है और खर्चा लगता है, पैसा है नहीं मेरे पास में इतना।
Okay.
पैसे दे दीजिए, आना नहीं होगा।
Oh, he is telling me.
पैसा देने के लिए मैं आपका है।
Please. बोलिए बोलिए हमको बोलिए।
हाँ, खर्चा लगता है और बहुत तकलीफ होता है, तबीयत खराब रहता है।
इसलिए हम क्या किया तो थोड़ा आफ्टर समर वेकेशन के बाद दे दिए आपका डेट। ओके, कोशिश कीजिए। ओके, और अदरवाइज इफ यू कैन
Steps in whichever way the law gives me the latitude.
ओके 13 जून महीना में। ओके, थोड़ा गर्मी कम जाएगा, कम हो जाएगा। My Hindi is not very good.
It is equally better than Mr. Dasgupta and me combined.
Handicapped. Okay, and Mr. Mitra?
I have.
Yes. Okay.
Can it be on 12th? One day, 13th. Very well.
ठीक है।
I'm deeply obliged for your lordship's compassion.
At kota बोलना?
At 12:50. 12 June at 12:50.
No, you being advocates of both sides, I request not this matter. We should cope up with the present situation regarding. We shall start.
In another VC is going to start in court number 3.
Say evidence, recording of evidence.
No.
Outstation counsel.
We shall start evidence, recording of evidence through virtual. Not when he will be in judgment debtor's side. Okay.
This has happened before our.
Yes, certainly happened. Not a new thing, but it's going to be a new normal.
Yes, new normal.
It is going to be a new normal. Okay.
Let us break it through from this court.
Okay.
Not from this matter.
Not this matter.
Not this matter.
Not this matter. I am not saying anything. Okay. Okay. Aki. Oh, তাহলে সেকেন্ড পেপার আসতে হবে কেন কি আছে দুটো আবার দুটো আছে তিনটে আছে দুটোর মাঝখানে কিছু তো রাখতে হবে না ওটা ইয়ে দাসগুপ্ত সাহেবকে নিয়ে ওকে এনার্জি এই ওইটা একটা অর্ডার লিখে দিতে হবে, যেটা বললাম না চেম্বারে গিয়ে দেখবো। লিখে নিন তো একটু। হুম। Heard the learned counsels list the matter or orders on ওই কত মানডে কত
Lordship, fixed matter for argument, item number 31.
May I commence my arguments? আচ্ছা, আমি জানি না। Lordship, before I commence, Lordship, may I take your Lordship to your Lordship's order dated 23rd of August 2023, Lordship.
The testamentary suit.
This is a testamentary suit.
So a contested suit.
This was initially contested. However, by order dated 23rd August 2023, Lordship was pleased to discharge the caveat which was lodged along with the affidavit in support of caveat. Now, that is the purpose why I invite your Lordship's attention to this particular order, because this is where Lordship was pleased to record that by an earlier order, may I place this, Lordship? Learned advocate for the plaintiff is present. None appears on behalf of the defendants. Learned advocate for the plaintiff has drawn attention of this court to the order dated 16th of August 2023 passed by this court. The excerpt of the order dated 16th August 2023 is herein below. Court, however, let the suit be listed after 1 week, and if the defendants do not appear on the next day, their caveat shall be discharged in accordance with law. As the defendants on their learned advocates did not appear, it appears that they are not eager to contest the present suit. Accordingly, the caveats filed by the defendants are hereby discharged. Now, in respect to my petition, there was initially a caveat. An affidavit in support of caveat was also filed, but pursuant to this order, the defense has been struck off.
Who filed these affidavits?
Now, this affidavit, now Lordship will kindly take the petition. Now, this is the Lordship will remember Justice Krishna Kumar Mitro. He was a retired judge. Now, he had several brothers and sisters, and he died bachelor. Now, upon his death, his surviving heirs were his surviving brothers and sisters. Now, the person who had filed the affidavit and lodged the caveat was actually his nephew, one of his brother's son. Now, Lordship will kindly come to
How many nephews filed this affidavit of caveats?
Now that.
How many caveats are there?
One caveat has been lodged. Lordship will.
What is his name?
Now, his name is Mr. Anando Mitro, Lordship. That is an affidavit affirmed on 22nd of April 2021. Perhaps the Lordship is in the record.
Anando Mitro, Anando.
Yes. Yes,
Anando Mitro.
Anando Mitro, he is son of Dr. Kollan Kumar Mitro, who is one of the brothers of the testator. Now, the brothers, Lordship, I have a genealogical table annexed to my petition also. He has.
And who was the beneficiary?
The beneficiaries were also, now here, Lordship, the beneficiary is one of the nephews.
One of the nephews.
Yes, Lordship. Lordship, in fact, Lordship will if I shall place the will, there are certain movable objects which has been given to brothers and some immovable properties which has been given to some other brothers. I shall place the will. Before that, Lordship will kindly take the genealogical table annexed to my petition, where the surviving brothers and sisters and or their children were cited upon in pursuant to my filing of the petition,
So,
which is annexure E to my petition, the
where,
genealogical table.
the page number?
This is not paginated, Lordship. This is annexure E of the petition.
এটা কি দিয়েছো? ফর্ম দিয়েছো? এটা? Annexure?
Probate petition. Annexure E to my probate petition, Lordship. My petition for grant of probate.
Yes.
Lordship, this is the genealogical table. Lordship will find Krishna Kumar Mitra since deceased 3rd September 1989. He died, and he was survived by all his brothers and sisters, save and except the extreme right side, who is Bishwanath Mitra, who had predeceased him. Now, the rest of brothers and sisters died subsequently. That is on.
They're all brothers or
Yes,
sisters.
brothers and sisters, Lordship.
Okay.
And I have cited upon the surviving children of these brothers and sisters. And thereafter, pursuant to such citation, one of the nephews, that is Ananda Mitra, lodged a caveat and thereafter filed an affidavit in support of caveat. And thereafter, Lordship was pleased to discharge that caveat because they did not contest the suit.
So, the nephews or niece of Dr. Dev Kumar Mitra,
Yes.
Dr. Shiv Kumar Mitra,
Everybody has been cited.
Dr. Kullan Kumar Mitra,
Yes, Lordship. Everybody has been cited. There is no objection from any of the branches.
Santi Bose, sister Santi Bose.
Yes, Lordship.
Was the legal heirs of Santi Bose?
Shanti Bose is survived by husband was there, Lordship. Shanti Bose had died in 5th of December 2011 and was survived by her husband, who had been residing in Salt Lake. He was cited, Lordship.
Issueless.
Issueless, Lordship.
Have you mentioned that?
Lordship, this has been all upon citation has been completed. Thereafter, only one contesting heir is the nephew who had lodged the caveat.
No, I have the authority
Orders
to
have
go.
been passed, Lordship. Will kindly.
Whether there is a mistake before passing final order, I have to check.
Yes,
Only.
Lordship. That is the very reason why, Lordship, I had drawn your Lordship's attention to this particular order, 23rd August 2023, and order dated 16th August 2023,
Yes, I have got.
where Lordship was pleased to record that only one nephew had contested. And thereafter,
I recorded as per your submission.
Lordship, I had filed the report. The report is on record. Lordship will kindly take the report also. তোমার কাছে citation এর report টা আছে? Lordship, it is for me. Lordship will kindly take the records with respect to citations. Affidavit filed by Mr. Devashish Mojumdar, which records.
Earlier, he executed another will on
Yes,
24th August 1988.
Yes, Lordship. That is referred in the present will, the subsequent will.
Yes. But why there is a change?
There was a change, Lordship, in his last will, Lordship. This was executed in presence of several witnesses, and Lordship had the attesting witness had deduced that he was present, and in respect to his reasoning, Lordship, that will appear from the will itself. I shall place
Who was the beneficiary of that will?
the earlier will, Lordship, was I believe one of the nephew was the
Who lost caveat?
who the caveator was a beneficiary.
Beneficiaries. So
That is the whole purpose of lordship. That will was not exactly a will also. That has been deposed by the executor. Lordship will remember he had deposed that how his uncle had expressed to him that it was not a proper will. Since he was a retired judge, he was aware of the form, the contents, and the nature of a document which can be a testamentary, can be a testament.
No, but in spite of that, he signed that will, previous will.
No, Lordship
Even
will now
you
kindly
as
come to the will.
judge.
Kindly come to
Honorable
the will. It refers to the particular
Yes.
what has been, I believe.
But
Lordship
within
will-
7 months, he died after executing the
Lordship will
last
kindly
will.
come to the third page of the present will, 15th of February 1989. Any other document executed by me, which was in the form of a deed of will, or which can be construed as a deed of will, particularly a deed executed by me on 24th of August 1988, must be treated as null and void and shall have no effect in respect to dedication of my property. This has been specifically stated in his subsequent
Yes,
will.
I have seen. But what is the reason for?
Lordship, the reason
You have mentioned that that was not in proper form. That's why he wanted to change. But why there be change in beneficiaries?
Lordship, that perhaps is not the scope. Lordship will see the in even the subsequent will be considered
that is the law.
valid and binding. And the reason will appear from, if I place the entire will from page 1 itself. Lordship will kindly take the will, which is Exhibit A7, appearing at pages 1 of the Judge's Brief of Documents and the original annex to my petition.
Yes, tell me.
I, Krishna Kumar Mitra, son of late Phonindranath Mitra, retired judge, High Court, Calcutta, now being aged 79 years, do execute this deed of will out of my free will, uninfluenced by anybody, completely voluntarily, in order that my properties, both immovable and movable, might be disposed of, appropriated, obtained, utilized, and enjoyed in the manner herein below stated. I am mentally quite fit and sound. Being advanced in age, I feel it is necessary to express my long-standing desire as to mode of disposal of my properties, of which I am the sole and absolute owner. My immovable properties comprise of 1/2 share in the land with buildings standing within an area of about 11.75 kathas of land noted as plot number 478 Damdam Park, Calcutta 7,55,000 in the registered and books of Krishnapur Refugee Cooperative Society. The property stands registered in the name of myself and my third brother, Dr. Devkumar Mitra, by a deed executed and registered by the aforesaid society in our favor. The brick-built structure, partly two-storied, was constructed thereupon. I have thus got 1/2 share of interest in that land and house standing thereupon, and the other 1/2 share of interest belongs to Devkumar Mitra. Besides, I am a co-sharer to the extent of a little more than 1/6 share in the house property, standing within an area of about 3 bighas of land, situated in Mohalla Kendudihi, within Bankura municipality, which was obtained by me and my other 5 brothers by right of inheritance on the death of my father Phonindranath Mitra on 15th April 1951, according to Hindu law of succession and inheritance. So, I give away absolutely my share of interest in these 2 immovable properties to my third brother, Dr. Devkumar Mitra, who is already a sharer in the Damdam Park property and a co-sharer in the Bankura property. In fact, my indebtedness to my brother, Devkumar Mitra, is limitless, as he rendered all assistance to me in all my difficulties which I had to face in my life, particularly after the death of my father, as being the eldest son, to meet the needs of my family members comprising of my mother and brothers. Besides, my other brothers, including the heirs of my deceased second brother Tirtho Kumar Mitro, have got their house properties of their own. Thus, the entire building, standing within an area of 11.75 kathas of land, is bequeathed and given absolutely to Dr. Devkumar Mitro, my third brother, according to my last desire expressed in this will. Besides, I give and bequeath my share of interest in Bakura property as stated before to him. Thus, all my immovable property is absolutely and fully given and bequeathed to him. This is my last will executed on 15th day of February 1989. Then he signs. These are all identified by the attesting witness. I appoint Dr. Devkumar Mitro, Dr. Kollan Kumar Mitro, and Mr. Somnath Mitro, son of Dr. Devkumar Mitro, executors of this will, who on proper application shall jointly or severally obtain probate. Regarding my movable properties, I give my car WB 8958 to Sri Subroto Mitro, son of my brother late Tirtho Kumar Mitro, and my other car WBC 1573 to my brother Kollan Kumar Mitro. Any other document executed by me, which was in the form of a deed, Lordship, I have placed this earlier, or which can be construed as a deed of will, particularly a deed executed by me on 24th of August 1988, must be treated as null and void and shall have no effect in respect to dedication of my property. It does not, of course, mean any of my brothers, sisters, and nephews shall have no access to this house, but their entry or stay should be treated as permissive possession, having no right to force their entry or stay on the basis of any share of interest in the property. Hereby, I dedicate as my last desire by virtue of this will. Now, thereafter, there are witnesses who were present, and the second witness, Mr. Mihir Kumar Chaudhary, had adduced evidence, and he has identified the signatures to have been put by the testator in his presence as well as in presence of the rest four attesting witness.
So who was the, whether it is letters of administration, who applied for the probate?
Now, Lordship had seen there are number of executors in page 2, second last paragraph. There were executors Devkumar Mitro, Kollan Kumar Mitro, and Somnath Mitro. And then the surviving executor, Dr. Somnath Mitro, has applied.
Applied.
Yes, Lordship. And the other executors had expired by the time the application was made.
So this probate will be granted in favor of whom?
The probate should be granted in favor of Somnath Kumar Mitro because that has been his application, executor, and Lordship page 9, page 4 of paragraph 9 of my petition. The fact of the death of the other executors, joint executors, have been pleaded. Paragraph 9, page 4 of my petition for grant of probate.
Para 9. That. Yes.
Now, Lordship, coming to the proof, Lordship.
What is your prayer?
Lordship, for grant of probate because in favor of Somnath Kumar Mitro.
And who are the beneficiaries?
Beneficiaries, Lordship, I have indicated the the beneficiary is the father. Lordship will find he has expired. Now, in respect to the movable property, the son of the beneficiary is there, and Lordship, the
will was executed when?
89, Lordship, 1989.
What about this condition of those two cars?
Lordship, that Lordship has been Lordship. May I take your Lordship through the evidence? The executor has adduced evidence why there has been a delay. First reason, Lordship, he was aware that there is a will, but he could not trace the original since this was not registered. And second, Lordship, he had fallen ill because of which he had lost. Lordship will kindly take the deposition, which Lordship I was about to take your Lordship through.
No,
Kindly
I want to know the condition of those two cars.
Lordship, the
1989 cars.
yes, Lordship, 1989 onwards, Lordship, he has explained why there was a delay in his finding. First of all, there has been a delay in petition. Lordship, the car, Lordship, that car has already been given, I believe, during his lifetime.
How without my permission, how can it be given?
Lordship, that
So matters of
that car,
estate,
Lordship,
movable.
affidavit of assets আছে, affidavit of assets আছে.
You take instruction then.
Lordship, what appears, Lordship, is the testator had, pursuant to his will, had already given the car for usage to these persons, to the beneficiaries. So, Lordship, when the affidavit of assets were prepared, it was no longer, Lordship, incorporated in the affidavit of assets.
Then that's a
Lordship,
mistake. I don't know what to do now, right now. As per
it should have been part of the
it should have been.
Yes, Lordship.
There will be a technical defect. I don't know. You cannot bypass the properties mentioned in the. Can you?
Lordship, it shouldn't have happened. Lordship, it should have been incorporated in the affidavit of assets and later on come with an explanation that it was retained by
Now
the
what can be done?
Lordship, if your Lordship permits it, the affidavit amend করে দাও. It's a very old car. They are vintage car, I believe. I doubt the existence of
So
it.
you did not look into this matter, madam.
Yes, Lordship. What appears is that the affidavit of assets were also.
You take
at one point-
instruction. You take instruction. Otherwise, how can you? You cannot guess.
Lordship, may I permit? So the problem is, Lordship, the beneficiaries were given, the asset was given by the testator during his
Whatever it
lifetime.
may be, I do not know. You know law better than me.
No, Lordship,
Okay.
I bow down to you. What the
Yes,
query
now
of your
tell
Lordship
me
has fell.
what.
May I ascertain this?
Yes,
In any
you take
event, Lordship,
instruction
the
and come back.
executor can, Lordship, file, when he files the accounts, Lordship, he has to identify that these
You are
assets
being
have already
assisted by
been.
an learned advocate.
Yes, Lordship, I shall
Yes.
take my instructions.
Yes, he is all through. He is proceeding with this case before me. Okay, now he did not look into this matter also.
Lordship, may I come back with instructions
Yes.
on this?
I do not know. The law is very clear. You cannot bypass or you cannot avoid the movable assets reflected in the contents of the will. So how can it be?
Lordship, what, but just
Now, what would be prayer now?
Lordship,
Learned
I
advocate?
shall- Lordship, I shall ascertain. Lordship, what is happening, Lordship? This, as personally I have seen, Lordship, many of in our country, Lordship, lot of people do not know that a probate is to be applied for the will. This is one of the big problem. There's no awareness of.
No, this drafting was done by able lawyers. That is the different thing. The parties are different, but you have drafted this.
That is there, Lordship.
So what can be done? I
By
cannot.
that time, the cars have already been, Lordship. This is
Whatever-
very old cars.
Whatever it may.
9, Lordship. By that time, they have used it also.
Also.
Even if not used, may have been in the garage
Take
and lying,
instruction.
nobody knows.
No, no. If you continue your argument, you can. But
Lordship, may I continue my argument?
yes, continue
Through the extent of the merits,
for
Lordship.
6 minutes because there is another matter.
Very well.
Yeah.
Then, in that event, in the next day, I shall continue.
No,
Lordship, subject
I
to this
thought that I
instruction.
could have completed, but suddenly it appears
Lordship,
that
these are-
2 cars
Because this will
you
is
have to
also-
mention. Then explanation. And that explanation can be accepted. But you cannot bypass.
If today, Lordship, it is
This-
found that the cars are lying at a garage, will that that itself will invite the necessity of incorporating it in the affidavit of
Yes. Whatever it may be, you take instruction
Very
and
well. I shall.
so when you come back,
Any day, Your Lordship, please.
you can carry out for 5 minutes. You can carry out for
Very well. Lordship will kindly take the affidavit, the deposition of the executor, that is PW2, Lordship.
Yes.
Lordship, he is also a doctor.
This is Mr.
Somnath Mitra, Lordship, is the
This is
executor.
Dr. Mihir Kumar Choudhury.
No, that is PW2, Lordship, is Somnath Mitra.
Yes.
Lordship, I'll kindly come question number 1. I have question number 3, Lordship will see.
Yes.
Can you say what was the age of your uncle, Justice Krishna Kumar Mitra, since deceased, at the time when he executed his last and final will dated 15 February 1989? He was 80 years old. Can you say how his health was in February 89? When he had executed his will, he was physically okay, but not in the best of his health, but he was managing well as expected at that age. How was your relation with the testator, Justice Krishna Kumar Mitra? He was being my eldest uncle, and I am being the youngest nephew. We had a good relation and quite friendly relation, basically. Are you aware that at the time of death of Justice Krishna Kumar Mitra, who were his surviving legal heirs? All his surviving brothers and sisters. Do you know the date of death of the testator? Yes, 3rd September 1989. How did you come to know about the will dated 15th February 1989, being the last and final will of Justice Krishna Kumar Mitra? Justice Krishna Kumar Mitra told me that there is a will, and I was made executor of the will, as well as my father and uncle. Do you know who had the custody of the will dated 15 February 1989? I guess my father had a copy and it was lying with him, but I was not here in Calcutta up to 1991, since I was in Indian Army, and so I used to come and go. From 1991 to 1994, I was in Calcutta. In 1994, I moved abroad, and then I had no idea where the will was. I came back in 2002 and searched for the will because I knew there was a will. I did not get the will with my father, and in 2009, I closed my father's locker. And during the closure of the locker, in the meantime, his father had expired. I closed my father's locker, and during the closure of the locker, in the corner, I found something rolled. I took it out and found that there is the original will. Are you aware whether there was any other will than of 15th February 1981, 9 of Justice Krishna Kumar Mitra? When the objection was made, a document was given to the court, which is still there, and that is why my uncle made a depiction that no other document was signed in the form of a will. Shown Exhibit A7, which is the will. Kindly have a look at Exhibit A7 and tell the Honorable Court, is this the document you are referring to, which is appearing at the first page of paragraph of page 3 of Exhibit 7? Yes. Kindly tell the Honorable Court, what is this document? This is the petition dated 30th November 2011, which was been signed by me. Are the contents of the petition true or incorrect that he identified? What do you have to, are you aware that question number 14, Lordship. Are you aware that one Anando Mitra has filed an affidavit in the instant case? He says yes. Question 15. What do you have to say to that? I do not have anything to say because they are otherwise natural legal heirs for the will, and anybody can put an objection. I do not think anything in that objection is true. Lordship, this in answers to question numbers 9, Lordship, and 10, he has explained his absence, like why there has been a delay for a long period.
Okay. That's all for today.
Very.
Yeah, the learned counsel for the executor. has commences her argument but does not conclude. When you will come back
And
after
next week, Lordship?
next week for argument or taking any other step?
Any day, Your Lordship pleases.
No, I cannot complete the argument
Very
unless
well
you.
then. With the instructions,
Otherwise,
Lordship.
I shall have to
Then may it appear after the vacation. In the meantime, we shall take.
stop. The learned counsel for the executor has further prayed for accommodation, since according to her the record is required to be.
Lordship will kindly not record. Lordship will allow me that my client is not in station in Kolkata. I shall take instructions and come back.
The learned counsel second line take it. The learned counsel has prayed for fixing the further hearing of the argument after reopening after summer vacation. Stop. Please the matter. একটা ডেট দাও তো হ্যাঁ for further hearing of argument. Okay.
I'm grateful. I'm grateful.
We have tried your level best. Okay. 13 June.
My learned friend was arguing, so I think she will continue.
Yes. আমি একটা নোট রেখেছিলাম।
Item number 20.
আর কিছু বাকি নেই তো? আর কিছু বাকি নেই তো? Uncontroverted affirmment. This was your last argument. 1996, 1966 or 56?
66 allowed 156.
156,
Page
yes.
one. And I was in paragraph 4 of my affidavit in opposition.
Yeah. Para 4, yes.
Up to 5, Roman, subparagraph Roman 5, it was over. Only we are in Roman 6. Roman 6.
Yes.
May I read? I most respectfully state and submit that the application for grant of probate has been made by playing fraud upon this honorable court, and the petitioner in the instant PLA has, in collusion with the and connivance with some interested person, manufactured the alleged will. It may not be out of place on my part to even state that the said impostor Himanshu Swain did not attend the funeral of my late husband, and he did not attend the search ceremony. Yet he claims to not only have been appointed as the executor but also the beneficiary, both exclusive. So much relation he showed that he got the property as it so. He didn't attend the funeral. He doesn't attend the search ceremony or even thereafter what he did so many years. Well, in 2007, 2009, he has filed this PLA. Filed this PLA. But there was no notice, no iota of notice, because at least I didn't come across. Well, then twice this probate application was dismissed, then restored, again dismissed, again restored. 2009 to 2023.
This matter, testamentary suit.
Testamentary. It cannot be said as yet testamentary suit, but it's a probate application.
Probate application was dismissed.
Dismissed.
At that time, you did not appear, no?
No
Right,
knowledge.
sister.
No knowledge.
Yes.
But in June 2017, being GA3633,
In June,
June 2017, GA3633 of 2016 was dismissed for default.
GA দেখো তো ও এটা তো থাকবে না আছে
Copy of the
please number please tell me the number once again
copy of the order public
tell me the number once again
3rd January 2017.
GA number টা চাইছেন
GA number
GA number as I found 3633 of 2016.
yes
Before that, well, on 15th of March 2016, PLA was dismissed for non-prosecution. Then there was GA of 17, which was also dismissed. So far, I could gather it may be more, but now this is at least as it is being shown, is a third time. It was made alive. There was no notice. Finally, I don't see anything. And we were also on the notice. I think I have given a Xerox copy of that. And normally, what we find from the notice, public notice, is public is being called. Whosoever has the interest may join or may approach the court on such and such date. Lordship, when you look at the language, well, it is two 1 Arati Sarkar. Wife of Atma Sarkar and the address, then Madam.
এই দাও নোটিশ একটা আছে না হ্যাঁ yes So it has become a letter, madam.
His address is, Madam, if you, as mentioned above, are claiming to have any interest in the estate of the deceased above named, are hereby cited to come within the returnable date of publication and to show cause as to why probate of the last will and testament dated 17th day of August 2000 of the deceased above named should not be granted by this court unto Himanshu Swin, son of late Jagannath Swin, residing at so-and-so address, being the sole executor under the last will and testament of the deceased, under pain and contempt of the law, and further to do this and receive as to law and justice shall appertain, and what you shall do, you shall duly certify. He is being directed to certify. Shall duly certified with the present to our said justices. You are hereby informed that free legal services from the High Court Legal Service Committee as per eligibility criteria is available to you, and in case you are eligible and desire to avail of the free legal services, you may contact the above Legal Services Committee. The matter will appear on 13th of October. Witness, another Chief Justice, then it's a very, I have never come across the learned registrar original side puts a full name and then he signs.
No, what happened? This requires approval from the department.
Department, and that
How they have no, that legal services facilities should have been
that is all right.
it's all right.
There, but this was issued by.
But even if the publication contains the name of the register,
No,
yes.
and I have never come across. It is always registered insolvency. Or maximum what, right? Register insolvency instead of SD register. So far, the
Is uncommon.
original side rules are concerned, under chapter 35, registered insolvency is also a register, known as register. So when it is written as only register, SD register, enough. Not like the full name. And thereafter, my lord, one Pranay Kumar Saha, who is he? What business he has? Well, he is a staff of testamentary department. I know he has harassed me a lot while I went to file the caveat. But how he comes? His staff never settles the publication. Even if they do, their name, at least I have not come across that their name is being published. But even before that, notice appears to have sent according to the petitioner, and it came back that so-called RC Sarkar. It came back as not known. But if I am residing somewhere for some time, and I leave that place, somebody goes to find me out, what people around, what they say. She used to stay here, now it is not known. I don't think I'll have to explain it. It's not known.
Not known.
Not that not found, not known. So that means at that address, nobody with that name used to reside. But my learned friend says, given three judgments. One is 2054 Supreme Court to the Bulgari to Bulgari.
AIR 1954 SC 280
54 Supreme Court
and AIR 2015.
2015. And there is one,
2007, Patna,
Malad.
110.
Malad, everywhere it is said the probate court will, of course, grant the probate, but definitely not a red carpet order. Probate court has to satisfy itself regarding the execution and all other associated. Malad. And it is said that probate court may not go through the question of the title of the property that has been given to bequest, but not so far execution of the will is concerned. In none of those. On the contrary, let's say today I have only one copy, and next day I'll file it. Even constituted bench, full bench of the Supreme Court says that even a registered will, nobody will get a red carpet order, even if it is a registered will. And in that particular case law, the probate application was allowed, then went to High Court allowed, then Supreme Court has dismissed that. Let us say the probate application, so naturally everything goes because it was a doubtable circumstances. There are 16 attesting witnesses, and it was elaborately mentioned, and wife in the will, well, there was no provision. Only some maintenance she was given, but what maintenance and what amount of maintenance the wife should get during lifetime, that wife was deprived. So I think, well, it's subject to correction, that wife filed this application for setting aside. That it is spurious. Well, I'll give that, because even if it is a registered will, well, red carpet order will not be there. Well, next time I'll file that.
What?
That 62 Supreme Court. 1962 Supreme Court. দাঁড়ান দেখি আমার কাছে আছে কিনা, আমার কাছে একটা কপি আছে।
নাম্বারটা বলবি?
হ্যাঁ, দেখছি। Five 67.
567.
Is a
A-
full
AIA?
AIA 1962
1962?
Supreme Court.
Yes,
567.
567.
It's a full bench judgment.
So you have only one copy.
But I have only one copy. I'll make it, next day I'll file it.
Okay.
Otherwise, I'll take out the book, and from making copy from book, it's next to impossible. So since I have already made one, I'll give it to you next day. But this full bench was presided over by my Lord Justice Wanchu. My affidavit in opposition, paragraph 5, can I start?
Yes.
Without prejudice to what is stated here in above, which are true and correct, and fully relying thereon, now I deal with the allegations made in the said alleged petition. Save what are stated here in above, which are fully true and correct, and save what are matters of record. I deny and dispute each and every allegation made in paragraph 1, 2, 3, 4, and 5 of the said alleged petition, which are contrary thereto and inconsistent therewith, as if the same are set out here in below and denied and disputed in seriatim. With further reference to the allegations made in paragraph 5, I state that there was and is no existence of any Srimati Arati Sarkar alleged wife of the deceased. I also deny in particular that the said Srimati Arati Sarkar claiming to be the alleged wife is in any way heiress of the deceased as alleged or at all, which is nothing but the brainchild of the petitioner. Such fact will support from the service report of the post office as not known. That's it. But save what on matters of record, I deny and dispute each and every allegation made in paragraph number 6 and 7 of the said alleged petition, which are contrary thereto, since there was no existence of any Srimati Arati Sarkar, question of her alleged last known address did not and does not arise as alleged or at all. Alleged last known address is not known. Came back. But it is to mention that the petitioner was directed by the Honorable Court to publish notice in the daily newspaper Statesman, both in English and Bengali, but the petitioner published the notice in Telegraph and Bortoman, and thereby flouted the orderable direction of this Honorable Court. Well, this is subject to correction. I have got from the record. To avoid prolixity, paragraph 8. To avoid prolixity, I repeat and reiterate the statements made herein above, which are true and correct, and deny and dispute each and every allegation made in paragraphs 8, 9, and 10 of the said alleged petition, which is contrary thereto and inconsistent therewith. I again state that the alleged will is manufactured and brainchild of the petitioner, which does not contain the genuine signature of the deceased. There are several anomalies. No death certificate of decease is filed with the probate application. Only a copy of an irrelevant death certificate is filed. So,
Why this is irrelevant?
May I stop here for a moment?
Yes.
They have filed a supplementary affidavit disclosing a copy of death certificate. Lordship, kindly take that.
Why we have supplementary affidavit, we have filed the original death certificate. Previously, copy was filed. Don't try to mislead the court.
No, I never said so.
No, you are saying, you are saying copy filed.
No. Copy, I mean, never said the copy file.
No, I'm sorry to interrupt.
Copy was given to me. A copy was given to me.
Copy should be given.
Lordship, kindly look at that alleged original.
Original.
আমি একবার original চাইনি supplementary
Supplementary করা আছে ছোট্ট একটা with the leave of the lordship of the earlier officer, not before the lordship but the other bench.
Okay. Yes. That original certificate is before me. Do you want to say anything in respect of this certificate? Yes.
But the name, so far it appears all right. Look at the father's name. Sort of like D.L. Sarkar. Well, in the petition and the will, what name appears? Even in my application, even in my affidavit in support of my caveat.
উইলটা কোথায় গেল উইলটা কোথায় গেল
Will.
Yes.
Opening paragraph. This is the last will and testament of Ashok Kumar Sarkar, son of late Rai Bahadur Yogendranath Sarkar.
DL Sarkar has been written.
DL Sarkar. Even abbreviation Yogendranath Sarkar doesn't come, the DL Sarkar. So my there is anomaly. So I say it is not the actual death certificate of the. Paragraph 8 of my affidavit. Towards middle. I again state that the alleged will is manufactured and brainchild of the petitioner, which does not contain the genuine signature of the disease. There are several anomalies. No death certificate of disease is filed with the probate application. Only a copy of an irrelevant death certificate is filed. Was I clear? So far, my inevitable interest is concerned. I am the legally married wife of the deceased, which will be supported by the order of the Honorable Division Bench of this Honorable Court, reported in All India Reporter in 1988, Calcutta, at page 2, page 124 to 131. Xerox copy whereof is Annexure 2 and marked as Annexure A. As such, the property ought to have been devolved upon me and or the deceased only son, namely say Indranil Sarkar and or Indra. But this case law has shown so she was gone there, 1980, 88, Calcutta.
Yes. They have read extensively, you.
Because I didn't.
You have to prove.
I
have to show. Yes.
In paragraph 9, I deny that the application being the alleged petition is made bona fide or for the interest of justice as falsely alleged in paragraph 11 or otherwise or at all. 10. I state and submit that there was no reason under consideration for the deceased to create any will in favor of the petitioner. I further submit that since the petitioner has committed a serious fraud entirely upon this honorable court, he is not entitled to any justice, relief, or order, in as much as fraud and justice cannot coexist.
And dwell together.
And they cannot dwell together also. You see that its petition is liable to be and be dismissed with exemplary cost. I also further most humbly submit that this honorable court may be pleased to deal with the said petitioner with heavy hands. But then thereafter, my lord, paragraph which are true to my knowledge and is what. So for my affidavit is concerned, my lord, in reply, my lord,
they filed the affidavit in reply. Hey, কোথায় affidavit in reply টা দাও? Yes.
naturally they are only denied. Regarding Arki Sarkar, there is regarding service, no detail. It is denied. Affidavit of asset, but that I'll come later on. Now, this affidavit portion is to be finished first.
Okay.
But in reply, what you said, I have gone to from second paragraph. I have gone through a copy of the purported affidavit in opposition filed on behalf of the Cavity, which has been forwarded to by learned advocate hereinafter referred to as the opposition. Said opposition. And I have understood the meaning and purpose of the same. Before dealing with the material portions of the said opposition, it is submitted that the Cavatrix has deliberately did not annex any document in support of her alleged contention that she was the married wife of the deceased in the goods, that is Anand Kumar Sarkar. It is further submitted, paragraph 300. It is further submitted that the Cavatrix has failed to annex any document in support of the child, namely in the Sarkar, alias Indro, alleged to have been born out of marriage wedlock between the Cavatrix and the deceased. She has also failed to disclose. The other day, on inquiry from my lord, I said that son is not my biological son. It was his son, of course. It was not my biology. I have never seen anywhere that he was born out of our wedlock. I have never.
His biological son of Asim Kumar Sarkar.
No, he is his son, but his mother left. I think that Lordship has noted on the last occasion will ask me.
Who was the mother of Indranil? Name?
Name Manjula Banerjee, and that's all.
Okay.
He has also failed to disclose when the child was born, but that was not necessary here because I should come and I should tell my lords what is my capacity, and then somebody else will come. The Cavatrix has also failed to annex any document regarding the marriage with the deceased alleged to have been occurred on 30th November and the wedding reception on 17 December 1976. It is further submitted that in service copy of the affidavit in opposition, the Cavatrix has deliberately kept blank about her age. Part 4. Now I shall deal with the paragraphs of the said opposition. It is categorically denied that the petitioner is nothing but an impostor, fraudster, land grabber, having money and muscle power, who has already committed and continues to commit perjury and play fraud upon the Honorable Court, as alleged in paragraph 2 of the said opposition. It is further denied that the petitioner formed a syndicate with some interested person with a view to grab properties of the deceased, to achieve which goal he had or has been trying to establish false status with a
Fabricated.
Public manufactured will, as alleged in the paragraph under reply. The alleged contention of the Cavatrix are without any basis and only to damage the character and good reputation of the petitioner without knowing anything about the petitioner. The Cavatrix cannot make any such allegation which is highly defamatory. I make some defamatory portions there to take action against me. Save and accept what are matters of record and what are specifically admitted herein. I deny and dispute each and every allegation contained in paragraph 4 and subparagraphs thereunder. What are
Contrary
to the record, and I call upon the Cavatrix for strict proof of the same. With reference to the alleged claim of the Cavatrix in paragraph 4 of subparagraph 1 of the said opposition, I call upon the Cavatrix to produce documents in respect of the marriage of the Cavatrix with the deceased at the time of hearing. I also call upon the Cavatrix to produce all the relevant papers and documents in connection with the suit for restitution of conjugal right in the Learned Civil Court in Calcutta and the order passed by the Learned Court by dismissing the said suit and alleged paragraph 4, subparagraph Roman 5, Roman 4 of the said affidavit. The cavity did not annex any document deliberately with some ulterior motive. Well, I have shown that the institution was dismissed. Then this honorable court restitution decree was passed. That
From reported judgment.
So I don't need to give him that. Well, it was there now. See the paper. I think I am saved, and to that extent, Lordship is satisfied with that. With reference to paragraph 4, subparagraph 5 of the said affidavit, as it appears in the copy of the order annexed to the annexed A to the said affidavit. The cause title in the said order refers to the name of some other person. Well, I have never come across it. It's printed, it's some other persons. And not the caveatrix and the deceased. It is not understood how the said order is related with the caveatrix and the deceased. It is strongly denied Well, again, my opposition paragraph 4.1, he dealt with 2 and 3.
Opposition.
My opposition.
Para?
Para 4, subparagraph 1, he dealt with in reply.
Yes, yes.
But 2 and 3, he didn't deny. But
Just
that
a minute.
I have given already. That 66 Calcutta, Allahabad.
No, he asked you to produce some documents
Yes.
regarding a wedding ceremony and
Yes.
But this is a reply. We should deal with all the paragraph of my opposition.
it remains uncontroverted according to you.
Subparagraph 2 and 3 of paragraph 4 again. Then 4 he gives 4. Then 4.5 he gives reply. Well, paragraph 6 may I read, Malan?
Yes, yes.
With reference to paragraph 4, within bracket 5 Roman of the said affidavit, as it appears in the copy of the order annexed as annexed A to the said affidavit. The cause title in the said orders refers to names of some other person and not the caveatrix and the deceased. It is not possible. I have told your Lordship that when somebody like Chatterjee, CHTERJEE or JI, Mukherjee also like that, Sarkar SIR, somebody writes SARKR. If it is while court is dictating, if it goes SARKR, but other relevant things are all right. Got it?
Yes.
So it's another name. It is strongly denied that the application for grant of probate has been made by playing fraud upon this honorable court, and the petitioner has, in collusion and connivance with some interested persons, manufactured the alleged will, or the petitioner did not attend the funeral of the deceased, nor did he attend the sad ceremony, yet he claims. But he has denied, but he never said that I attended, or for this reason I could not attend. So it is only mere denial. Yet he claims to not only have been appointed as the executor, but also the beneficiary.
What are you doing? এই দেখো কি বলছেন দেখো। Yes.
The court is not functioning. She understood that the court is not functioning. The court is going on. Oh, sir.
কি চাইছে?
কি চাইছে জিজ্ঞেস করো না।
কি চাইছে?
No, no, ঠিক আছে।
আপনি junior member of your
ঠিক আছে। All right.
Yes.
Has been appointed as executor, but also the beneficiary, both exclusively, as alleged in paragraph 4, subparagraph 6 of the affidavit. The alleged contention in the caveats are totally false. How only it's false? How it is false? The deceased, during his lifetime, on several occasions, visited the subject property with his wife, Shrimati Arti Sarkar, and had a very close relation with me. But pause here for a moment. I also gathered some information. Because after 2000, he did not go for a single time to Diga because he was being frightened. Because several papers were being signed. So after that, he became frightened, and I think there are several wills.
No, is there any pleadings to that effect? What my learned friend is submitting? I am objecting to that. There is no pleading to that.
Yes.
effect.
Please
Speak to her pleadings only.
Yes,
Nothing
yes.
new.
Yeah. Yes.
They're not in record. Pleadings.
What made him not to make this probate application in the Midnapur court?
Yes.
That would have been much easier for him. Nobody would have been there to contest because there is existence of another will, and that will didn't come because there is a patch up with the one of the attesting witnesses. Lordship will find that will, how the will is executed, no read over and explain whether will was read over by himself or not. I am the writer, I am the executor, I am the beneficiary, I am everything. But there is no as such witness. Two witnesses, both are from Midnapur, not from this side. Then there was no read over and explain. There was no doctor signature whether it was well off or not, which normally will contains. Advocate, who is the writer, who drafted it, Lordship will not find anything. There's only two persons' name is appearing. That too, because one was signing in English, another one is Bengali. Lordship, usual practices, there has to be read over and explained.
Even if the testator is literate and educated in spite of that.
I'm not talking about the testator. Even testator never says that he has gone through it. Lordship will kindly go through the will.
Okay.
I have gone through the will, and then with full sense I'm signing. And having understood. If something is done with a professional, and if something is done with some particular intention, without taking help of others.
Is there any prescribed form for drafting a will? No, I am not asking you. I am asking her.
But not very specifically. But these are things. This has to be in the will.
Yes. I should look into that.
But the case law I have given, that case law is given that there is no read over explain.
Okay.
Any will, any scriber.
Yeah, 1962 SC 567 or
567. It's a full bench judgment. Justice Wanchu was presiding over that.
Yes.
The alleged contention of the caveats are totally false. The deceased during his lifetime on several occasions visited the subject property with his wife, Srimati Arati Sarkar, and had a very close relation with me. He also executed a power of attorney in my favor to look after the subject property, and also to pay all taxes in the name of the deceased in Digha, Sarkarpur Development Authority, local Gram Panchayat. The deceased also took a huge sum of money from some other story is falling here, not in the petition. Now he says that he took huge sum of money from me, which he didn't pay back. This is a new story. It was not in the petition.
It may help you also. Next.
Well, I clearly to produce all those necessary papers. Well, the death certificate of the deceased at the time of hearing of the power of attorney executed in my favor at the time of hearing. I'll produce. Well, what you will produce, the original death certificate that he has already filed.
And power of attorney.
There are anomalies. My father is not there.
Power of attorney.
Power of attorney. Well, we are least concerned about the power of attorney. Power of attorney, we cannot deal here. Because if he is a beneficiary, if he is an executor, power of attorney doesn't require. On paragraph 7, with reference to paragraph 6 of the said affidavit, I repeat and reiterate the statement made in paragraph 1 to 5 of my petition, and I strongly rely upon it. It is further denied that there was and is no existence of any other Sarkar wife of deceased as alleged in paragraph 6 of the said affidavit. It is also denied that Srimati Arati Sarkar is in any way not the heiress of the deceased and is nothing but the brainchild of the petitioner. In the service report, the post office are not known. It is stated that the deceased in his will itself has specifically mentioned the name of Srimati Arati Sarkar as his wife repeatedly. The alleged contention, the caveat is that Srimati Arati Sarkar is not the wife of the deceased as alleged, is totally denied by me. It is not understood. When the caveat is specifically stated that he had no connection with the disease, that after he left at the end of 1977, said subsequently he did not come back in a matrimonial home. Lordship can recall, Lordship asked me several questions regarding that. After that, whether we had that, I replied, well, do I require it to repeat it? Well, as I told my lord, that even after that, even after passing of this maintenance application, but in several courts this matter took place. It was not over in one day. Almost all the honorable judges, that's particularly, they called us, trying to patch up. You go there, like that. It was not. Normally, in matrimonial matter, they do it. But each of them made me cautious that you are not going to go alone. He says, you can go with somebody or you go alone, but you take at least one of your colleague. Right to my colleague is there. And well, this is never misbehaved. Also, he never, I don't complain about his misbehavior, no. And I visited this place, well, his landlady is the witness, because his landlady also called us from veranda. She was hearing all this, then he says, please come. We went up, we sat there, and whenever I went there, I visited her. It is just about it. There were several visits. Only the thing is, we were not staying together, but coming and going started. Maybe after two months.
But have you mentioned anywhere that you had no connection after he left you?
No, I have never mentioned.
But that has been mentioned, I think.
I have no connection. My learned friend will show it.
Okay.
I have no connection. I have nowhere.
He's
And
alleged.
he didn't come back after that. It is understood when it is not understood as to when the caveatrix has specifically stated that he had no connection with the disease. After he had left in the end of the year 1972, and subsequently he did not come back to the matrimonial home. Then the caveatrix had know about the rest of the life. I don't know the meaning of this. But the disease till his death, 29th March, and after having no connection with the disease about 30 years, now the caveatrix has come with her alleged claim. In this context, I have failed to understand how we can allege that I did not attend the funeral, nor I attend the sad ceremony, for which I cannot be appointed. That means clearly it is admission that he didn't attend the funeral. And I know he didn't attend because I was there also. And he didn't deny, Melody. He didn't deny. Because I didn't attend there, it doesn't mean that I cannot be given property, I cannot execute the will. That's a different thing altogether. But a person is giving me his valuable property so thick and thin.
No, he is saying that after having no connection with the deceased about 30 years, this is allegation against you. That after having no connection with the deceased about 30 years, now the caveatrix has come out with her alleged claim. In this context, I have failed to understand how she can allege that I did not attend the funeral. You had no connection for last 30 years. So how it is?
Yes, it is.
So how can you say that he did not attend funeral? In some way, other way around, he has denied.
Not attend. Had I not attend, how do I know who came? Who else came?
So all these are factual aspects.
It's a factual aspect. And well, I'm trying to
Require evidence.
No, I'm trying to find out because after such ceremony,
Where the such ceremony was taken place?
It was taken place in Taliganj.
Taliganj. Anybody's
Film service.
Oh,
It was a rented place.
ceremonial house.
Yes.
Okay.
It is not like today that it is very well decorated, but film service, Lordship must be knowing, next to film service. It was a part of film service. Because I knew that the surrounding is technician studio, NTR and all. Most of the artists, they reside close by. They will come naturally. I needed a bigger place. After that, I gave a publication that showing my gratitude that whosoever came, I am very grateful.
When it was taken place?
I'm trying to find out that one. Maybe 2-3 days after the such ceremony was over.
So you have organized this.
Naturally, my lord.
No. Do you have any photograph and anything else? Any paper, any invitation card or something like that?
No, in fact, invitation card, then I would have to distribute. But I didn't have
This is my question,
no,
just to.
No invitation card. I didn't. But only the thing is, in paper, after the ceremony was over, in Bartoman, I gave that just to show my gratitude. That
Have you brought that document? That
I'm trying to find out that because I never knew that after 2007 this would be the.
You have to face this.
Well, as I'm still, I said I'm trying to find out that because I have given a Shangbad like
Yes.
Post, so it was.
Bring it.
It was published.
Yes.
Published. That I showed my gratitude that whosoever came there, I'm very grateful. It's like that in Bengali.
Who performed the rituals?
I did it.
No, you did it, but his biological son?
No, he says because of this kind of behavior, he was very much ashamed. He disowned him. This is no entire relations. Entire relation.
And what about his mother, Manjula?
She left long ago. Left long ago.
She did not take care of her son.
No, because take care of son, I have heard that he got him admitted in St. Paul's. Then I went along with him, and she used to visit sometimes, studying St. Paul's. It was a boarding house, so he was put there. But when he little grown up, so he didn't like all this.
Okay.
Because of all the relations, I have in any occasion, they do invite me, but none of them was in any way was related to him.
Okay.
Like this kind of behavior in ordinary family, nobody likes it. So naturally was little isolated. But I still enjoy that because anything happens in the family, I am an invited there. In my in-laws, I'm talking of my in-laws.
Okay.
My elder brother-in-law, we call it in Bengali Bhashu. So his sons, daughter.
They are alive.
They are alive there. Any function, the granddaughter.
They used to come.
They used to come, and I used to go to them.
So there are so many witnesses in your favor to support that you can produce all those witnesses.
To produce all those.
No, I am giving you some clues to prove your case.
Who could give this? They are elderly people.
Yes.
Now the next generation, of third generation. The other day, the grandson is birthday. They call. Kaki Thakuma, please come, like that.
Okay, please.
So our contact going was there, and still that since he has expired, it doesn't mean that our relation. We have like in Vijaya and all functions. Vijaya time, they come to me, I go to them, and like Holi, we go to Pranam and all this. Still, usual relation is still there. Normal usual relation.
Okay. Next.
Para 8 murder, with reference to the allegations made in paragraph 7 of the said affidavit, I repeat and reiterate the statement made in paragraph 6 and 7 of the petition and strongly rely upon the same. It is categorically denied that flouting the order direction of the Honorable Court publication was made in the daily newspaper, Telegraph and Bottoman, and not in Statesman as a review. I think that will come from the record, madam. With reference to allegation made in paragraph 8 of the said application, I repeat and reiterate the statements made in paragraph 8, 9, 10 of my petition strongly rely upon the same. It is repeatedly denied that the will is manufactured and brainchild of the petitioner and does not contain the genuine signature of the disease. Or there are several anomalies in the death certificate filed with the probate application, and only a copy of a irrelevant death certificate is filed as alleged in paragraph 8 of the said affidavit. But if I have shown this one, in this context, I call upon the caveatrix to produce before this honorable court the original death certificate of the deceased at the time of hearing as to the alleged contention of the caveatrix. I say that the signature appearing in the will is a genuine signature of the deceased. I call upon the petitioner to produce any document in connection with the subject property before this honorable court. But I do not know. I call upon the petitioner to produce any document in connection with the subject property before this honorable court. I don't understand. It's in reply, written in reply. I do not know what is the meaning. and how it is related to me. Alright, paragraph 10. It is further denied that the caviatrix has caviatable interest as the legally married wife of the deceased, which will be supported by the order of the Honorable Division Bench of this Honorable Court, reported in AIR 1988. All of the pages 1240. Well, I have never shown any 1240.
This is typographical error. That's good mistake.
131. As alleged in paragraph 8 of the said affidavit, I call upon the caviatrix to produce any document to show that she never received any
See ever,
show that she ever received any alimony from the deceased. I strongly deny that the property ought to have been devolved upon the caviatrix and the deceased only, sir. Well, whether I have received the alimony or not, it is not the subject matter of this, nor he can be in any way connected to whether and I have got any obligation to show him that yes, I got it. If I wouldn't have received any alimony, court was there, I would have gone. But in any way, that doesn't come on the way so far this proceeding is concerned. 11. With reference to the allegation made in paragraph 9, 10, and 11 of the said affidavit, it is strongly denied that there was no reason under consideration for the deceased to create any will in favor of the petitioner as alleged in paragraph 10 of the said affidavit. It is categorically denied that the petitioner has committed any serious fraud inter alia upon this honorable court, and he is not entitled to any justice, relief, or order, inasmuch as fraud and justice and fraud cannot coexist. Very together.
He has also denied this proposition of law also.
Well together doesn't carry any meaning. It has to be dwell together. Well together, as alleged in paragraph 11 of the said affidavit, is further denied that the petitioner is liable to be and be dismissed with exemplary cost, as alleged, and I repeat and say that the will of the deceased is which probate has been prayed for is a genuine will, and there is no question of committing any fraud upon this honorable court. Para 12, it is submitted that the caviatrix has failed to prove her caviatable interest to oppose the grant of probate, and she had
No right.
not right over the property for which the petitioner has applied for grant of probate. It's further submitted that the caviatrix has failed to annex any document about the alleged marriage with the deceased, as also the child born out of the marriage wedlock. Accordingly, the Honorable Court would be pleased to discharge the caveat filed by so far. I have shown reasonably enough that what is my interest. Well, my interest is not to grab this property, I don't need it. But only the thing is, it shouldn't go to a wrong person. There are several institutions. It can go to somewhere else. I don't need anything, a single father. But only the thing is,
Only I am here to execute the desire of the testator.
My lord.
If it is the desire of the testator that it should go to the religious institution or charitable, it's certainly. But I have to ascertain what is the real intention of the testator.
That is the thing is, without going to lordship has to satisfy lordship, satisfy the court that it was executed in a right way and the probate can be granted. That far and no further, but this court has to see.
I have to sit in the armchair of the testator. Okay.
Well, the thing is, lordship has to see the actual will was at all executed or not.
No, right now, what is the stage of this proceeding is that he has filed one application stating that you are not the wife of Mr. Osim sir, that is the only point to be decided right now. Am I correct? That petition is, what is the number of that petition? GA8. GA8 wants that your affidavit or something like that, you have paid for filing a caveat or something. What happened?
Because after seeing this advertisement, I approached the Honorable Court, Justice Majumdar. He said, go and file caveat immediately. So I filed the caveat. Then thereafter, this question came that whether
in support of caveat affidavit.
In support of caveat.
So that is complete.
That was there.
Now he has come with an application that alleging that you are not the wife of the testator. So you have to show that you are the wife because 106, the special knowledge lies with you. You have to prove that you are the wife. So you have shown me certain reported decision. Now that Samuel Sirkar and you are the one and the same. You have to show.
That is for my lord.
How?
Because
there is no Aadhaar card. That at that time there is no Aadhaar card.
The voter
Voter list
Voter ID card was
not there. Not there.
It started only in the
Yes, I understand.
1994-95.
I understand.
Before that,
You showed some documents, such as that the gratitude you shown after the Shraddh ceremony. You have just right now you have argued that you have published one gratitude in Bardhaman.
That is in Bardhaman. After
You have to show some.
Well, I'm trying to find out. Lordship knows that 2007. Well, who keeps this kind of, because I never dreamt of it that today I may have to face this.
After all, according to you, he was your husband. You should keep all these things for memories or
Well, memories for memories.
Memorable thing, memorable mementos.
These doesn't come within the purview of the mementos.
Whatever it may be.
Mementos, you can call that first time he was given as a best actor. That memento I have.
Showing that name of your husband. No. Yes. So you can show anything, any document.
It is not a document, it's a memento.
As per Evidence Act, not only the paper, anything inscribed, written on a metal brass can be done.
It was a ring.
I do not know whether
I say it was a ring in a box, which is written there.
You show me. I do not know what can be done.
Because
I cannot give you any.
Because after 30 years,
clue.
I can. Because I never dreamt of it that I have to see the light of today. I may need something. I don't need.
So you can produce oral evidence then. Bring witnesses, elderly couple. Maybe.
After 30 years, nobody wants to come to the court.
Something has to be there. Because there's.
I have given in Bardhaman, I'm trying to find out.
Oh, yes.
That one memento I have.
Yes, try.
And another memento is a very weighty.
I do not know. I do not.
But the small one I can bring it. That was his first.
Whatever it may be, I have to check and so that I can assist. I can be assisted by you to come to a proper conclusion. Okay.
Because giving probate court, just red carpet cannot give. That is only my thing. He has to prove his will.
Yes. But before that, he has raised certain objection regarding your identity. So you prove your identity so that yes, you have shown certain matters before me. But yes.
And this matter ought to have been tried under Rule 28, not Rule 30. It would have been much easier because court's valuable hour would have been limited. Now this and that, because maybe finally your lordship has to go there and under 28.
Yes.
Because that is to be treated as a suit.
No, not at this stage.
Okay, when you have completed, I think, just to
show my that
judgment.
payment if I can bring and that.
আমি আপনার আপনি বলুন
Like they will.
Not payment, you have to produce this before this court, and that shall be kept with the record in safe custody or something like that. Yes, I will try to give you time.
Whatever is there. For
Yes, sir.
this, your lordship doesn't have to give me time because I think if I search within 2 or 3 days, I can bring it because as a memento, I kept it.
No, you
Is
come back with all your materials. One day I can give you 10 days time if you.
All I do not know, but this and the Bottoman publication.
Yes, come back after 10 days or 15 days.
30 years, I may be needed. With this idea, nobody gives something. Well, regarding will, I'll go through the record and this affidavit of asset and all this, whatever he has given. I'll have to show.
Mrs. Sarkar, SIR has resumed her argument but does not resumes her submission but does not conclude. Stop. This the matter after 14 days.
আপনার লিখে দিন
এটা অরিজিনাল সার্টিফিকেট কি আছে এটা দিয়ে ও এটা তো অ্যাফিডেভিট ঠিক আছে এইটা কি আছে দেখো আচ্ছা এগুলো নিয়ে নাও ও ডেটটা বলে দাও ওই কনভেনিয়েন্সটা দেখে নাও ঠিক আছে
16th May.
Weeks বললেন তো।
That's all for today.
16th I have no difficulty. 16th or 14th, 15th.
Madam.
Lordship kind.
Lordship will fix the time. Only
Yes.
Time is too fixed.
Time is very crucial.
Also. Definitely after in the second.
So one Seta Mukherjee is appearing. He is junior or something. Yes, I have seen that Seta Chatterjee. Shreya. Oh, I see.
But if it is 16th, sir.
হ্যাঁ no problem 16 আরো কিছু আছে তো দু একটা আছে তো
কল করে দিচ্ছি
fix up the time. Time
করে দিচ্ছি
24th after court hours
আরো এক সপ্তাহ
summer vacation will start after 14th May 24th May sorry 24th May
before vacation
16th হ্যাঁ 2 p.m.
at 2 o'clock. At 2
2 o'clock or 3 o'clock.
আপনি 3 o'clock এ যাচ্ছেন কেন সময়টা
2 p.m.
3টের সময় হলেই তো রেস্ট অফ দ্য টাইমটা পাওয়া যায়
হ্যাঁ 3টে করে দাও
দুটোই করলেই তো অন্য লোকে
অন্যরা পাবে না
3টে বলছে
3টে হলে হবে কি মোটামুটি লোকে জানবে কি এরপর টাইম পাবে
I see Lordship, it is 3 o'clock.
3 p.m.
আপনার শেষ হবে
আমি I'll go to the records if not today and the next day.
No, you can go to the records in presence of both sides. Miss Shreya Chatterjee will be here with you. If
the originals of everything, copy of which has already been served.
No, I have nothing. আমার কাছে উইল নেই আমার কাছে এফিডেভিট অফ অ্যাসেট নেই এগুলো কিছুই তো
yes you can check both
not only I have already applied for the inspection but that is there.
Okay,
that application is there.
liberty is given to you. Okay,
item number 27
183 PLA 18309 na 09
item number 28
309
item number 29
what happened to you? It was cool, it has become cooler. Oh,
I'm for the plaintiff. Item number 29 is my senior matter. He has joined virtually, but her video is not working. So praying for not today.
What was her? What is her name?
Shweta Mukherjee.
Oh, that's why. Okay, so not today.
Yes.
Not this week.
Not today.
Not today. Okay.
item number 30 not today
Nahi. Okay. গরম করে